All right, the first case we call is Sharp versus Winterville Police Department. And Mr. Tutt, I think it's you first.
Thank you, Your Honor. Let me get my mask off. May it please the court. This case raises questions that strike at the very heart of the First Amendment's most important protections. The right to film police officers in the discharge of their duties in public, subject only to reasonable time, place, and manner restrictions, is a clearly established First Amendment right.
Can I ask you this? This is a sort of a preliminary question. The briefs on both sides spend a lot of time talking about a First Amendment right to photograph police work in public, whether by the press or friends or other people watching. And cases seem to support a First Amendment claim there. And the debate in the briefs seemed to be whether the Fourth Circuit ought to do that. And my question is whether that's relevant at all. In other words, it seemed to me that the issue we have in this case is what may the police do to persons that are subject to a Terry stop or a traffic stop or an arrest. In other words, when they're in the police control, what may the police do? And usually we start that type of analysis under the Fourth Amendment. And if we do it that way, the analysis is different from the way you guys have advocated in the brief. Both of you have done this. And so that's my own take on this, is that this is a traffic stop. And during a traffic stop, there are a bunch of incidents that the Supreme Court has recognized, the first of which is both the driver and the passenger are subject to the stop. And they both have about the same rights. And the police officers have about the same rights with respect to them. For instance, you can tell the guy to step out, sit on the curb. You can, if a statute says you can require him to answer his name, you can require a bunch of stuff. You can probably, if he has an open gun, you can probably say, just for the purpose of the stop, let's remove the gun. If you're worried about it, you can frisk. So there are a whole bunch of incidents under a traffic stop. And in this case, the officer says, we're not going to have live broadcasting. He says, you can film it, but we're not going to have live broadcasting during the stop. Now, the question is, if I'm right about this is a Fourth Amendment question during a stop, what's the analysis that we have to follow? Well, I know your First Amendment arguments, and well, they're standard, yeah.
Your Honor, if this were a Fourth Amendment case and there were a Fourth Amendment analysis, I think the analysis would be completely different, and we don't raise a Fourth Amendment claim for that reason.
I understand, but
I
don't understand. It's if the police officers arrest somebody and take them into a questioning room at the police station,
yes,
and they start questioning him, they take away his cell phone. Absolutely. And they say you can't make a call.
Yes.
If you invoke an attorney, we'll stop questioning you. You can call an attorney, and they have that control. Now the question is, why do they have that control, and why doesn't it apply in a Terry stop or a traffic stop?
I think, Your Honor, that is in the case, and it's an important question, but it's analyzed under a First Amendment analysis in this case. And the question, yes, Your Honor.
I'm questioning about. In other words, it's not a First Amendment case because it's First Amendment to the extent that the police officers' rights to control the circumstance impinge on the First Amendment. But, you know, the officer tells them to sit down at the curb. That's First Amendment, freedom of movement, and it impinges on that. It tells them you can't have a gun during this stop. That's Second Amendment. You go down the whole list that during the stop, he gets certain rights. And so to the extent
but not all rights
about people in the public photographing police work or the press photographing police work, to me, from my own point of view, that's irrelevant. I think the question you ought to be addressing is what rights do the officer have during the course of a traffic stop?
Your Honor, the officer doesn't have, I want to make this clear, has no interest in privacy with respect to a traffic stop that happens on a public street.
His argument for suppressing telecommunications He even said you could photograph, but he said the telecommunications is the worry about interfering with the stop, interfering with questioning, safety, somebody calling a gang around the thing. All of these things are concerns that the officer might have if the people he's stopping are telecommunicating during the stop.
The difference here is that Mr. Sharp was merely broadcasting passively. That's what's alleged in the complaint. This went off on a 12B6. What's alleged in the complaint is that, and I think evident from the videotape, is that Mr. Sharp was passively recording what was happening, and the officers had no specific or articulable reason.
We can address exactly what happened factually. I don't think there's a lot of dispute of that. The record's a pretty good record. But my question is more of a categorical question, is what rights does an officer have to maintain control of the circumstances? That's what the Supreme Court has indicated the officer has a right to do during a traffic stop. And your argument is the officer may not stop broadcasting during a traffic stop because that infringes on a First Amendment right.
Not without further justification than the simple fact that the person happens to be in the vehicle that was stopped.
Well, let me ask you.
Can I just follow, but I want to make sure I understand the point. Would your argument be any different if the guy, your client, was trying to record after he was arrested?
It would be much different, yes, Your Honor.
Help me understand why.
For one, he would be in police custody, so there would be a completely different set of interests. This is a Terry stop where...
Right, but the challenge there is like, then that sort of suggests that Judge Niemeyer's got more of a point, because then it is the sort of the nature of the custody matters, right? And so the fact that he's under a Terry stop or he's in arrest, or maybe he wanted to, live stream his imprisonment, right? So he wanted to have a GoPro camera that he could live stream his treatment in prison. All of those things, it seems to me, have the similar First Amendment sounding interests.
They do.
But they have very different Fourth Amendment sounding interests. And so I think you can see that those are going to be treated differently. So help me understand why your point is that the Fourth Amendment issue just doesn't matter.
And the reason is that if Mr. Sharp had been being followed around by a live camera crew, for instance, let's say he was arrested and the live camera crew was following him, or he had a drone that was following him and live broadcasting what was happening, I think that the First Amendment analysis would favor Mr. Sharp because there wouldn't be a reason to restrict the broadcasting. What's at issue, really the core of the issue?
Those are the rights of the people those are the rights of the people outside the not being stopped. In other words, those are members of the public or the press. The question is, I'd like to get back to the question that was just posed to you, and that is, you agreed that during an arrest, he could not broadcast simultaneously, right?
On the assumption that he's trying to hold a phone in his hand.
It doesn't matter. During an arrest, they say they take his phone away. They have to get a warrant probably to open it up, but they take the phone away from him.
Well, that would be why he
Is that
couldn't...
legal?
Exactly, and that would be,
Okay,
these are incidental
impacts. Let me
impacts
ask my
on...
question, please.
Yes, Your Honor.
My question is, during an arrest, if the officer has a right to take the phone away and prohibit broadcasting, what is the reason for that?
That the individual needs to be detained or arrested so that they cannot take any action adverse to police officers. But an individual...
How does that accomplish that?
I want to answer Your Honor's question, but it's important to frame what Mr. Sharp was in this context.
But can you start with the question? Because I'm sort of interested in the question.
Yeah, if you are arrested, there's probable cause that you have just committed a crime, and officers...
That's no question. The question is, what is the value being served by removing a telephone during an arrest? Why is that appropriate?
I mean, you are restricted entirely of your liberties when you're arrested.
Why?
No, not entirely. If you hog tie them, right, we wouldn't say that's okay, right? There are lots of things that you can do, like maybe you got to be handcuffed, right, so that you can't get to a gun, but, you can hold your phone, right? That wouldn't necessarily be required for an arrest. And so
I mean,
why
we're
would,
talking
from a
about
First Amendment perspective?
technologies that don't exist, but if he had an implant in his eye that allowed him to live stream his arrest, there would be no officer interest in making
They
him
could
turn
take
it
it out.
off.
Yeah, they could take it out.
We don't
cover it up.
agree. We don't agree unless he's going to a
me ask
place
you-
that the police have an interest in privacy in. There is no rational
You
justification
just
for that.
agreed with me that the police during an arrest can take the phone away.
Right.
And prohibit let me finish the question, live broadcasting. I want to know what interest the officer has in removing that phone, and you haven't answered that
Yes,
question.
it's in restraining the suspect. It is not in.
What's he restraining? Taking the phone away?
People
is
are put in
restraining?
handcuffs when they're arrested, Your Honor.
Pardon me?
People are put in handcuffs when they're arrested and their individual
They may not be. They
possessions
can
are
be.
taken.
They can be, but the officer takes the phone, right?
I'm trying
Inevitably,
to,
they take the phone.
Your Honor, if there was a film crew following him while he was being arrested
Look,
and
I'm
they
not
were
talking
under
about
his
the film crew.
command,
I'm
so they were
talking
working
about-
as his agents,
You're
he
having
could still
trouble.
have them film him.
I think he's trying to ask you a question. I'm not sure why you're so excited right now, but I think you want to try to answer his question and not talk over him.
My apologies, Judge Richardson and Judge Niemeyer. I apologize.
This is the last time, and you can answer or not, but it's going to help me a lot in this case, is what is the value? You say he's under arrest. He has to have control. Is that the answer? In other words, to take his phone away, how does that further that interest during an arrest?
It furthers the officer's interest in arresting the suspect.
I
Arrest in
understand,
its
but take it further.
dictionary
What's that
definition
mean?
of
He's-
stopping any criminal conduct. The person has
and
been arrested.
taking the phone away does what?
Well, it protects the privacy of
Not
parts of the
privacy. It takes communications. It takes the risk.
police statement.
Interference. Right?
Police stations are private. The back of a police car is private. They have very fundamentally different privacy interests for the police, as First Amendment cases have pointed out. But I really think the reason that arrests can have,
Which case do you think says there's a privacy interest in arrest?
the one that says that when the government owns the property, it gets to control what goes on there. It's a forum doctrine case by
It's
Justice
irrelevant. I
Black.
think the idea is that they have taken control of the defendant, and they're controlling the circumstances, and one of the lack of controls is the communication with the public.
Mr. Sharp
Because of
could have been a
interference and
7-year-old
safety,
child.
right?
Your Honor, Mr. Sharp could have been a child in the
No,
car.
let's stick with my hypothetical.
He could have been.
Because
Families are pulled over on the roads all the time. I apologize, Judge Niemeyer, if I've interrupted. I'm just trying to get to the distinction, which we see as
I
very
understand,
straightforward.
but you're not answering my question or focusing on it at all. My next question, after we would explore that, would be why doesn't that value apply in a Terry stop or in a traffic stop? And I didn't get to that, but you can go ahead and make your argument.
Let me go back to this arrest idea, because I think the point that Your Honor is trying to tease out is you think that there's sort of a per se interest once an individual is arrested.
No, I'd like to know the actual value, the actual reason why it's we don't take off the guy's pin where he says, I am a Republican or I am a Democrat while he's in the car and arrested. But we do take away his phone. And the question is, why do we take away his phone? And the answer is, I think, is that it relates to both safety and to interference with the arrest. We do not want him communicating outside while he's under the control of the police, and we do not want him exposing the officers to further somebody else called in and all the dangers that could arise after somebody's been arrested. And so if those are the values of why we take, the purposes of why we take the phone away during an arrest, then my next question would be, why don't those same things occur when there's a traffic stop and the Supreme Court says that the officers have a right to control the circumstances and maintain control during the traffic stop of some half hour or whatever it is? And the court has said that 2 or 3 times.
So I think one thing is that this is an unexplored area of Fourth Amendment law. I don't have any cases where someone has asserted a Fourth Amendment violation for their phone being taken away. I don't agree that the principles that dictate why phones are taken away when individuals are arrested is so clear. And that's illustrated by the fact that the person could have a Confederate right there filming the entire thing happening, and we wouldn't think that it was okay to take that Confederate's phone away, even if that person was affiliated with the person who had just been placed under arrest. This is an important point because the difference between a mere bystander and the person who's actually being subject to a Terry stop or an arrest is often a very thin one. This case has important consequences for every police-citizen interaction in this circuit. If the subject of Mr. Sharp was not the target of this stop, he was a mere passenger in the vehicle.
Yeah, but you're now forgetting all the principles of traffic stops. Mims and all these other cases and its prodigy all have talked about the fact that the passenger is subject to the same control as the driver.
The same control, yes, Your Honor, but the interests...
He's in the same level of custody. It's not custody, not in the formal sense, but he's under the same control. He can be directed what to do. If there's a local statute that says he has to identify himself, he can force him to identify himself. He can make him sit on the curb. He can take a gun away. He can...
But there are limits, Your Honor, right? And we recognize that there are
limits,
very...
and we're exploring that today.
Yes, Your Honor, exactly. And so the strict limitations, we think that this falls well within the kinds of things that are off limits. They couldn't take his phone and search it just because they
He has
had...
to get a separate warrant to search it, but that's a different issue altogether.
So there can be incidental impacts on broadcasting. We don't dispute that. If they say we need to see your hands, he's going to need to put the phone down. If they say that he needs to step out of the vehicle, he will be required to step out of the vehicle. He's going to need to put the phone down. But the target in this case was the broadcasting.
And if the circumstance is justified, he can be frisked. The passenger can be frisked.
Absolutely. I mean, I don't dispute any what you're saying.
Suspicious items can be removed from his body.
I agree.
Okay.
I mean, we are in...
You couldn't do that to the press watching, or you couldn't do that to the public watching. So the question is, if we're under the Fourth Amendment analysis, what is the standard to determine whether the officers in this case acted appropriately?
Well,
No, my question, under the Fourth Amendment, what is the standard that we have to apply if we apply the Fourth Amendment?
I think that you have to apply a question of whether there is any reason specific to this traffic stop for denying Mr. Sharp the ability to broadcast the stop. So it cannot be a per se prohibition. And that's why the town of Winterville's policy is unconstitutional. There's not a sufficient... This case is important. It's going to dictate thousands and thousands.
Yeah, let's accept the fact that we have a policy here.
Yes, Your Honor.
I think you make pretty good allegations on that, and it's pretty clear what the policy is. The policy is that you can't live stream, but you can record and broadcast later. The officer made that clear. So let's assume that's the policy. What is the test as to whether that policy is appropriate during a stop?
That policy is appropriate where there is a compelling interest in prohibiting live streaming.
Where did you get that standard? Compelling interest?
Well, I think the whole policy...
I'm asking you, the policy regulates what police may do during a traffic stop.
Yes.
And the question is, what is the standard, constitutional standard for assessing whether that policy is appropriate?
Yes, Your Honor. Well, if it was an as-applied challenge, then it would be whether the specific officer had violated the Constitution by not taking the phone away for a compelling reason. But if it was a facial challenge to the policy, as this is, the question is whether this blanket ban can be justified based on the evidence that the city of Winterville has adduced, which is none, and is narrowly tailored, which it is not.
I respectfully suggest that I think the standard is reasonableness. That's where the court comes from, is whether the policy is reasonable. And this is a Fourth Amendment analysis, and I know your brief almost doesn't touch it at all. The government's brief does touch it and make the case, but they try to answer your First Amendment arguments. And obviously, First Amendment issues change when somebody's in police control.
Your Honor, we don't dispute that the First Amendment analysis here is different. Otherwise, these cases wouldn't even exist. There would be no plausible basis at all.
We have a case where the officer has said no live streaming, no telephone calling during a traffic stop?
We don't, but we think that's... Yes,
Nowhere
Your
in the
Honor.
country, right?
Well, no, Your Honor, we don't have any no live streaming case anywhere in the country, but we think that's because it's virtually self-evident that broadcasting is subject to the same analysis.
Person being stopped?
Yes, Your Honor. Yeah, yes, because if again, this is about a per se ban. The officers had no reason based on any facts. They just said that it was something that they could ban because they felt like banning it. They didn't say that this particular individual was inciting individuals to come to the scene or soliciting anyone to come. The officer let him continue live streaming, I think in large measure because the officer thought that it was okay to make an exception here because this case didn't raise any concerns, but next time your phone is going to be taken away from you.
Okay.
I think
you have some.
yes, Your Honor.
past the red light.
I appreciate the opportunity to
you
go
have
over
some
time.
rebuttal.
Thank you very much.
All right, Mr. Hartzog.
Thank you, Your Honors. May it please the Court, Dan Hartzog, Jr. As I think Your Honors have recognized through your questioning, this is not a case about whether there is a general right to record police officers in their public duties. That's just simply not before the Court. What is before the Court is the right of a passenger in a seized vehicle, lawfully stopped traffic stop, to live stream the encounter from within the vehicle, which is entirely...
Can I start with what I would have thought Mr. Tutt's answer was to Judge Niemeyer's question, is that often we have government action that could violate more than one constitutional provision. We think about that for example, the Fourth and the Eighth Amendment could go together in a particular context, or other government action that involves more than one constitutional provision. We tend not to permit that in the context of the Due Process Clause in the Fourth Amendment area because we think the more specific Fourth Amendment governs over the more general Due Process Clause. But is there any reason to think that the action here, why should we think that the action here could be wholly consistent with the Fourth Amendment and yet also infringe on the First Amendment rights? Assuming that they exist here, right? I understand on the merits maybe they don't, but wouldn't we think about those two violations separately?
Well, I think Your Honors have picked up on the fact that there is an intersection in this case between the Fourth Amendment and the First Amendment. And I think when you're in a setting of a traffic stop, the Fourth Amendment controls.
Well, but it wouldn't control, right? So the real answer is what the Fourth Amendment does in that context is it informs the government's interests a great deal, right? And might ultimately be dispositive about the government's interests, but we're still asking whether that's a First Amendment violation, right? The Fourth Amendment doesn't preempt the field, right? We just say, okay, whatever degree of government interest is required, and we can have that debate. I'm trying to bracket that for a minute. That question is informed by the government's interest in controlling the scene and ensuring officer safety, right? Those are vital government interests that are really important, and we see that through the Fourth Amendment in those lines of cases, but we're still analyzing it through the lens of whether this is a First Amendment violation, right?
Correct, Your Honor. And I think the answer to that is to the extent you're looking at the First Amendment analysis of someone in a traffic stop, what you're looking at is restriction on live streaming a reasonable time, place, and manner restriction.
Right, and so then
Is that what you think is the analysis? Every stop case from the Supreme Court, they start under the Fourth Amendment, and even though the rights being infringed are First Amendment rights, such as taking the passenger and putting the passenger under physical control, which is a First Amendment right, they never address the other amendments being infringed. Rather, they examine the Fourth Amendment seizure and determine whether the seizure and the conduct of the officers is reasonable. You don't see this in any of those cases where they said this interferes with, for instance, taking a gun from a person during a traffic stop. They don't talk about the Second Amendment.
Counsel, if I can just add to that and clarify, is it your position that the officer would have had the right to do what he did to reach in and try and grab the phone had the phone been off? In other words, simply as a Fourth Amendment matter during a traffic stop, can a police officer simply reach into the car and take the phone, articulating officer safety or controlling the scene?
I don't believe so, Your Honor, but that's obviously not the case here. What the officer was doing was he said, you cannot live stream. The individual continued to live stream in defiance of the officer's directive, which the officer clarified was for officer safety reasons. At that point, I think the officer does have the right, consistent with the Fourth Amendment, to, as same as you would seizing a gun, ordering the individual out of the vehicle, placing the individual in handcuffs for the duration of the stop. All of these things have been found to be reasonable in the context of a traffic stop. So I think
Well, do
seizing
they require the police officer to articulate some reason to infringe on a right? In other words, if it's a ordinary traffic stop for going through a stop sign and the officer interacts with the passenger and the driver, at what point can the officer then demand to have them get out of the car or to then frisk them or to then put them in handcuffs? Do each of those things require some fact on the part of the officer, or can every traffic stop become a traffic stop in which the individuals are asked to get out of the car and be put in handcuffs?
I think the general case law on this, Your Honor, is that the inherent dangerousness of traffic stops has been long recognized by the Supreme Court, not based on the fact that, well, this is just a minor traffic stop, but based on the potential for a traffic stop to turn into a more serious, potentially deadly, violent encounter.
So the mother of 5 small children who's pulled over for running through the stop sign can be viewed as potentially dangerous and has to be stepped out of the car and frisked because she might be armed?
Well, I think it's a reasonableness standard, Your Honor. And
Not frisk, though, right? You agree the
Correct.
frisk is a separate standard,
Correct.
right? You'd have to show dangerousness, but she could be asked to get out the car.
That's
Like,
correct.
that would be the categorical piece of that. Is she can be asked to get out the car. We might not love that, but the Fourth Amendment would say she can get asked to get out the car. If she's got 5 kids, she might want to get out of the car anyway. But she couldn't be frisked, right? Those are all the Fourth Amendment limitations.
That's right. You would have to have at least a reasonable suspicion of some danger, potential weapon to frisk. But
Do any of the cases, I mean, Judge Niemeyer's point's a good one. None of the cases, we talk about MILMs and these lines of cases, but did any of those cases raise a First Amendment claim? Or as he's, hypothesized, I mean, I haven't seen somebody actually, are you aware of a case where someone raised both a Second and a Fourth Amendment claim in the context of a stop and seizure? It doesn't, I hadn't seen that come up, but
I'm not aware of any such cases, Your Honor, nor am I aware of any such cases where, the plaintiff is alleging a First Amendment right, because typically these types of cases, traffic stops are analyzed under a Fourth Amendment standard. And the Supreme Court has held clearly that,
Right, but we would say, okay, totally legitimate, right? The officer stops the car, everything, Fourth Amendment is right, but then they beat the hell out of the guy, right? We would say, listen, the Fourth Amendment stop and seizure was great, but you can't beat the hell out of the guy. I mean, to me, like, that's fine. Yes, you can stop, and it may well be the justifications for the stop are adequate justifications under the First Amendment lens, that there's, as your colleague would say, a compelling interest, or however we want to frame the inquiry, there might be such an interest that is sufficiently tailored and all those things. But we got to look at it through the First Amendment lens, even if they complied with the Fourth Amendment.
That's correct, Your Honor. But I think in the context, and this is why this case is so unique. This is not a bystander. This is someone who is seized. And I understood plaintiff's counsel to say it would be different if the suspect were in custody, which Fourth Amendment case law is clear,
Right,
they
so,
are.
So this is the question that I want to ask. So assume, for just hypothetically, assume on the individual claims, I found that qualified immunity properly applied. But when I get to the official capacity claims, qualified immunity doesn't apply, and assume that I believe there is a policy, or at least they've adequately alleged a policy. Can we decide this case as the district court did without sort of development of the reasons for the policy? I mean, we're hypothesizing about why the town might have adopted this policy, whether the policy is specific. Your colleague wanted to say it needed some specificness to this stop. We don't even know what the policy is. So it's really hard for me to evaluate the policy, alleged policy, I should say, given the record that we've got, right? How can I reach the conclusion that the government's interest, whatever standard it might be, is satisfied when we've got really no idea what the government's actual asserted interest was when they adopted the alleged policy?
Well, I think you're right in the sense that if the court were to determine that there is a policy set in place, it would be difficult for this court to determine, the full constitutionality of that policy without knowing what the policy is, because the policy is not.
Or what the
specifically-
town's justification for adopting it was, or how it's applied, or any of those things.
Correct, Your Honor. And in all candor, if this court were inclined to believe that there is an official policy or custom, I think the appropriate result might be to remand for
What's
further
your position on that?
consideration.
They allege, and they have some pretty good background for it. They allege that the policy is that you can't live stream or telephone during a traffic stop. He said he wasn't bothered by the telephoning because as soon as he engaged the driver, he shut the call off. But the policy included telecommunications during the traffic stop. And he said that was for the safety of the officers.
I think you'd be looking at it as, is this policy a reasonable time, place, manner restriction on?
Well, why do you do that? I don't understand why you'd say that. That's not the Fourth Amendment analysis. The Fourth Amendment analysis is whether a policy of preventing live streaming during a traffic stop is reasonable. That's what the Supreme Court has said on all these cases. And reasonableness then determines whether it can be justified by officer safety or control or of the situation or whatever the value is.
I suppose my response.
But do you have a case where, when they tell somebody you can't move, you have to sit on the curb, and if you do, we'll cuff you. I mean, I think they can even cuff them to keep them in place there. That's an infringement of the freedom of movement protected by the First Amendment.
Well,
We have a time, place, and manner analysis or First Amendment analysis.
I suppose you're correct, Your Honor, that in this context of a traffic stop, perhaps time, place, and manner is not the analysis.
If this were a First Amendment case, somebody out in the street looking at traffic stops, and the issue was the officers wanted to back the crowd up and said, don't get so close, your cameras and phones, and they're going to interfere. The question would be, can he move the crowd back under a First Amendment analysis? Because the First Amendment is being exercised in filming the police work. But here we have somebody who is seized who wants to exercise telecommunications. And the question is, sure, it implicates the First Amendment. But do we apply the First Amendment standard, or do we apply the Fourth Amendment for the seizure?
I think, Your Honor, in the context of the traffic stop, you apply the Fourth Amendment.
But I thought a minute ago you agreed with me that you apply both, right? That it can comply with the Fourth Amendment and yet also violate some other constitutional provision. And the reason that the Fourth Amendment cases don't address First Amendment claims is because the First Amendment claims weren't brought, right? We don't have cases with Fourth and First Amendment claims, and we tend to address the claims that are brought.
That's correct, Your Honor. And that's where my time, place, manner comment comes into play, is because to the extent you're looking at, a restriction, to the extent the court believes there is a right to live stream, constitutional right, which has never been recognized, and, this court would basically, plaintiffs asking this court to recognize a broad right, unfettered, to live stream at all times, including during a traffic stop. And I think the Fourth Amendment comes into play on that part. If you're looking at whether there is a right to live stream police officers in the first place, I think then the time, place, manner restriction analysis comes in, and this would be a perfectly reasonable, targeted time, place, manner restriction, because the officer safety issue is a compelling, not compelling, a substantial government interest. Substantial and weighty is the term that courts have used.
What analysis is applied to an inmate who wants to exercise a First Amendment right from prison. He says, I have a First Amendment right to purchase magazines of all kinds. And the prison authorities say, we are going to censor those and we're going to exclude a whole category of magazines that you can purchase. And so what is the analysis that's conducted there?
Well, I think.
Is that a time, place, and manner issue?
Your Honor, forgive me, there is a line of cases on that very
Of course there
topic.
is. There's a whole line of cases, and it says you don't lose your First Amendment rights, but they can impose in furtherance of penological interests. And that's a tenafly, the whole arrangement there. But this is not a time, place, and manner under the First Amendment. We're in a totally different context.
That's correct, Your Honor. And I suppose there's some distinction between being in a prison and being in a public setting.
Of course there is, yes.
But again, the traffic stop is more akin to being, is closer to the prison setting because you're subject to officer seizure and control. And the Supreme Court has said that
Albeit
officers.
temporary and
Temporarily.
Well, let me ask you, counsel, at the very beginning of your remarks, and I don't want to mischaracterize them, I think you said the case is not about recording, and of course the officers conceded that recording was permissible. So is that your position, that had it simply been recording within the context of either the driver or the passenger, that would have been permissible? There wouldn't have been a basis under the Fourth Amendment to prevent that?
Your Honor, again, under the Fourth Circuit, that right has never been recognized. I understand there is a lot of case law in other circuits about the right to record. To the extent this court believes that is persuasive authority to the right to record,
Let me
that's
ask you,
this
the
court's.
right to record by somebody seized?
And again, that's the distinction in this case, Your Honor.
Well, that's why I raised it from the very beginning of this case. People on the street, the press, and other people observing police work are under a totally different circumstance. We're talking about what are the rights of a person seized. Do we have cases where persons seized under the Fourth Amendment have a right to record?
I'm not aware of any circuit case on that.
We don't have that issue before us, but
Right.
I just don't, your response to the question really was sort of a giveaway.
Well, Your Honor, I'm not aware of any decisions on that point. I think every circuit court that has recognized a right to record police say that it is subject to restriction. And so,
Yes, but that's the problem I had with your briefs. That addresses people's right outside of the police work to do it. I'm looking for the case, a circuit court case or Supreme Court case where the person actually seized is trying to record. Now, I don't think we have that before us. I think the policy alleged in this case is telecommunications during the stop. In other words, the give and take, the live streaming and the response or the telephone call. That is the policy described by the officer, and that's what they allege.
right.
But just going to the question of whether there could be, whether you have a right to record, if the policy said you can't record, would that be unconstitutional? I think it's a little bit out of the way here, but is there a case that addresses that? A single case?
Of the right to record from a
seized person.
I'm not aware of any court ever recognizing that right, Your Honor, and that's why this case is not clearly established. And
Can I ask a similar question there? So part of the declaratory relief that's sought here is that they had a right to record, and I take that to mean a right for a seized person to record, or a person in this context to record. Is there any reason they would have standing to bring that claim? I know you didn't raise a standing argument, but it's jurisdictional, right? Because here they were told they could record, right? So it seems hard for us to reach the question of whether a seized person has a right to record, because that was a right that was afforded here, and at least the allegations, as we take them, they wouldn't have a basis for claiming that.
I 100% agree with that, Your Honor, and I think the way they framed their allegation in the complaint was right to record and live stream. And so
So they lack standing on the record piece because the officer said that's permissible, and they only have standing on the live stream piece, sort of subpart B of the requested relief and the declaratory claim.
That's correct, Your Honor. They were told they could record. They were not stopped from recording. He said, if you record, that's fine. This is about live streaming. It's an officer safety issue. And, you know, if this court were to recognize some right to live stream from within a seized vehicle, that is going to be a huge officer safety issue that, you know, I don't think it would be appropriate to put in some blanket rule that you have the unfettered right to live stream from a traffic stop. Your Honor, I do see my time
Yes, I
is
do.
over,
Okay.
and I want to allow Mr. McGinnis to
All right,
speak.
we have Mr. McGinnis. As an amicus, you have 3 minutes.
Good morning, Your Honors. May it please the court, I am Michael McGinnis, and I'm honored to appear on behalf of the Southern States Police Benevolent Association. Your Honors, we rarely ask to come up here as we have in this case, and there's a reason why we're here, and it's because of the questions that you honors are posing. This court wisely prohibits counsel from live streaming in these proceedings. And I would assume it's because we don't need distractions and noises. Well, what's really different, Your Honors, about the seizure of a vehicle, that is an ongoing incident scene, and officers have legal duties, responsibilities, and protocols to follow. And what they're taught and trained is to look at these two things that God gave us, the hands, and things that are in those hands, especially when it is a metal object like a cell phone that can be and has been used as weapons.
So just for a second, assume that everything you say is like written in stone and accurate. Like, wouldn't we have to actually have some like findings on that? I mean, you might say it, I might agree with it, one of my colleagues might not agree with it, but the nature of the governmental interest requires like evidence, right? I mean, I might intuitively understand what you're saying, but my intuition about your truthfulness or the accuracy of the representations about danger, it seems odd that suffices in a First Amendment context, as opposed to needing, you know, witnesses and information about this is a real safety issue. You might be able to testify, or one of your members could testify, but I'm hearing it from you, and I feel like I'm listening to an expert, which is not generally what we do.
Your Honor, the court can discern from the record what was going on here, I believe, and the basic nature of what was unfolding at this scene. And when the officer, again, you can record, but you can't live stream. And the officer said, why? And that's in the record, Judge Richardson. The why part is important. Is because officers are well aware that those cell phones are used to trigger these electronic communications, and they can have gang members and other people showing up because
right, but we're going to make a judgment here. If we followed your path, we'd make a judgment. I don't even know what the judgment would be, right? Because we'd say a policy, maybe case specific, maybe per se, we don't know. It's not clear from the allegations, is supported by an interest in officer safety without any like evidence to support that, other than the officer saying it's true, right? But no development of that, right? You're saying it's true, and I full respect to your organization and you, right? But we don't tend to take evidence that way.
Yes, Your Honor, I agree. But again, I'm going to respectfully suggest that the court can discern from the record enough here. And if we apply this court's qualified immunity test from the could have reasonably believed standard.
Oh, yeah, I'm totally with you on qualified immunity. I'm talking about the second question, which is the official capacity claim.
Yes, sir.
Right? And in that instance, you know, what the court said was, the lower court said, yeah, this is about officer safety. And that might well be true, but it's hard for me to understand how I know that as an evidentiary matter, that that's a real government interest, whatever the standard, right? We can talk about whether it's compelling or substantial or whatever that means to the extent those are different. But how do I know that it's like a real interest without some evidence? In most First Amendment cases or other cases, we require some evidence of the interest.
Your Honor, I can certainly appreciate the court's desire to see more about it, but it's here on a Rule 12 review, and there is a record in there that you can discern from, and I think there's some reasonable
We're under
implications.
12C, right?
Yes, it was judgment on the pleadings, Your Honor.
And the complaint and the pleadings in this case include the transcript.
Yes, sir. It's
an exhibit to the complaint.
and the video as well.
Yeah.
So there seems to be far more than just a nominal complaint. And again, Judge Devers' analysis of that, and from our perspective, was very reflecting. Judge Niemeyer, just one final point for me, if I can. You asked a serious question about what is the value of the officer taking away that cell phone. And, sir, we absolutely agree. It is an objective reasonableness standard when an officer starts taking actions at a scene that are individual seizures. But again, sir, our point is when something is in a subject's hands, a wise officer is going to get those things out of his hands. Something as simple as an eyeglass case can inflict harm.
But that's irrelevant to this case because the officer didn't suspect this was a weapon and so forth. The question challenged here is live streaming during the traffic stop.
Yes,
and he knew he was doing it. The officer did not fear and did not impose any policy with respect to holding a metal device in the hands. I understand your point that that's a risk situation. I mean, the guy comes up with an axe or he has a knife in his hand or whatever. The officer says, I need to take that during our traffic stop, and probably would be upheld probably as a threat to the officer's safety. He has a right to maintain control and protect his own safety. Those are the two things the court has talked about, the Supreme Court. Anyway, thank you very much.
Thank you, Your Honor.
Mr. Tutt, you have some rebuttal?
Thank you, Judge Niemeyer. I would just like to hit a few points that came up at argument. I first just want to say, even if you take a Fourth Amendment analysis and say that there has to be some kind of objective reasonableness, anything that goes beyond the ability to per se stop recording or stop live streaming, any interest that needs to be specific or articulable to that stop would mean that we win this case, because there was nothing specific or articulable about what Mr. Sharp was doing that would have led the officers to believe that he was doing something dangerous. All he was doing was passively recording. And he was doing that for the same reason that many people take phones out when they interact with police. He was afraid.
But you know, policies are legislative in nature. They're
Yes, sir.
forward-looking for a full range of conduct. And we examine them in connection with stops for reasonableness. And the question is, the reasonableness here can be discerned from the nature of the policy and the imposition on the defendant or the seized person. Of course, here the officer gave specific explanations and circumscribed the policy, as he described it, was only the live streaming. He says you can record it, and after the stop is finished, you can broadcast it. But during the stop, so that is the policy he was articulating, and that's the one you're challenging at this point.
Your Honor, even accepting all of that, and we think there's a different analysis.
You alleged it.
Yes, but I mean, accepting the standard, the legal standard is reasonableness.
Yes.
Even accepting that at the policy level, the standard is unreasonable. There are plenty of individual traffic stops where either because of the nature of the stop or the people stopped in the car with the driver, there is no reason at all to prohibit live streaming. And so it would fail at that wholesale level of being reasonable.
What's the reason for officers removing people from the car and putting them on the bank during the stop? What's the reason for when they have some suspicion, permitting them to frisk everybody, even if the person doesn't end up having a gun, if they're suspicious? In other words, what is the reason for requiring them to identify themselves? That's been upheld, and local requirements to identify themselves. These are all categorical things that address the scope of the officers. It's not something they have to invoke every time. They don't have to take somebody out of the car every time, and they don't have to justify it when they do.
Your Honor, if you say that live streaming can be prohibited at a wholesale per se level, you will eliminate the right to record as well. because officers will always be able to say, I need to have your phone, I need it to be turned off.
The live streaming, if that's a prohibition, then you don't need to worry about whether it goes beyond the policy. The policy that the officer enforced was no live streaming by seized persons,
Your Honor,
period.
to ensure that officers will routinely tell people they may not power up their phones, they will routinely say you have to have
Wrong
your
with
phones
that?
in your
When they're
pockets.
If you were under arrest, would you let them power up? You told me that they would not. But while they're in the car under arrest, you agreed that they should not be able to turn on their phones. In matter of fact, their phones could be taken away from them. That's what you agreed.
Under arrest, yes. But
Under arrest. So my point is, there is a reason why they do that during an arrest, and it's just a categorical reason of safety, control, and preventing outside interference. Well, that same value applies when officers are trying to control a traffic circumstance.
I don't think it applies to the same extent. And all I will say is, if you go and look at those Supreme Court cases about traffic stops, the Supreme Court itself seems to be very reluctant. They see that as a necessary evil that the individuals in the car are also being subject to the seizure. And they have really...
You're reading. Then
Because
not only have they reinforced that and said it categorically, they have to keep reciting all the officers that have been shot during traffic stops. And they've, even recently, they recited that. They keep reciting updated data about the risk of forced stops and that officers can take steps categorically to protect themselves. And it doesn't matter whether the particular person is a widow or the person is looks like a tough guy or whatever. It seems to me that for protection, they can't make those judgments. So for protection, they go through certain procedures. If you know, every state trooper approaches a car from the rear and in a certain angle. This is a procedure they're taught in order for their safety.
Your Honor, this is, I can accept all of this, and I do accept all of this, and still say that the interest of the individual in the car and the interest of the public in being able to live stream what is happening or record what is happening.
Let's go explore that. What is the interest in a seized person who's going to be seized for probably no more than a half hour? We're talking about the length of traffic stops, and of course that's always the subject to lawsuits. How long can they last? But let's say a half hour. And he's told during the half hour, I don't want you recording or broadcasting. When we're done, you can do it again. Now, what's his interest in doing it during the stop?
His interest is both fear and actually deterring wrongdoing by the officers. So it helps to allay that anxiety that individuals feel when they are in a traffic stop with police officers and they don't know what those officers are going to do. There are people who fear the police. It's just an unfortunate fact. And the second interest, there's actually a third interest, which is the public's ability to see what happens. But the second interest is to hold everyone at the scene accountable. When a stop is live streamed, it doesn't encourage people to come to the scene and attack the officers. It encourages everyone on the scene not to take any unlawful actions. And that...
Can I follow up with just one question? I know we're well out of time, Judge, if you don't
Yes,
mind. So you said a minute ago, in a couple of different ways, but I noted again, there's no reason at all to stop live streaming. Assume for a minute, I think that's wrong, and that the question is whether the reasons for not doing live streaming justify a limitation, either categorical or case specific. We don't know because we don't know enough about the policy. If that's true, so I don't accept your view that there's like no reason whatsoever, is the right answer here to send it back to, in other words, vacate the official capacity claim with respect to live streaming, to allow there to be a record developed as to what the policy is? Like, is it categorical or case specific? And then B, what's the government's interest, and is it a real interest, or is it a feigned interest, or how significant it is? And then maybe, depending on what test applies, look also at the evidence of tailoring.
Your Honor, we think you should we think we pled the policy adequately. So we think you should address the policy on its merits, which is a policy prohibiting live streaming of police officers by passengers in stopped vehicles. If that is,
You think you've pled it as a categorical rule?
yes.
Okay. But in that, so I'll accept at least the theoretical point, but even so, if I don't accept your view that there's no reason at all to limit live streaming, right? As your colleague said, we tend to limit live streaming in the courtroom. So to say there's no reason at all seems a stretch to me. And the real question is the reason justify the action? That's a question that requires evidence.
Yes, Your Honor, but I also want to say that this is one of those questions that sits at a really difficult intersection between policies that can have evidence developed. I mean, all First Amendment restrictions, even the most draconian, could theoretically be justified, and they just would have to meet strict
But
scrutiny.
it does raise that question. It's an interesting question because it raises the question of whether we have to analyze statutes or regulations or policies based on evidence, or whether they can just be, I mean, I suppose a legislature can just pass a statute, put it on the books, and we analyze it under reasonableness as to its text and its reasonable effect. Why they did it may be totally obscure or not known, or may be different for every legislature. And so if we sent this back to find out who put the policy in or whatever, it seems to me that it's, and I think this is what you allege, we can assess the policy on its face, can't we?
Your Honor, I think you can assess the policy on its face. I think Judge Richardson is right, though, and I was just trying to basically circle back to saying it's correct, that this gets resolved at summary judgment. But we think we think they couldn't meet strict scrutiny. But if you think they can, or should be given the opportunity,
Where's the
then yes.
strict scrutiny come in?
We think that this is a content-based restriction because it only prohibits filming police officers. But
It's not based on content. It's basically, it's a prohibition during a stop not to record, regardless of what's being recorded.
even if it's intermediate scrutiny, it would still go off at summary judgment, I think, and I think Judge Richardson is
Well, then
right about
you're
this.
suggesting this whole case should be analyzed under the First Amendment standards as opposed to a Fourth Amendment.
Even under a Fourth Amendment standard, if you thought that there was a standard that the legislature had to meet,
There is a standard. The Supreme Court's articulated it several times.
we would still have to go to evidence to see if that could be substantiated. There would still need to be a justification for the policy.
Can I ask one other question just to give you an opportunity to respond to? You seek a declaratory judgment for two things. One is to record and one is to live stream. I'm simplifying slightly, but A and B in your declaratory judgment piece. How do I find that you have standing on the recording piece, given that the officer told your client that he could record? I have a hard time seeing under our standards of sort of imminent and likely repetition that you've got standing there.
Two reasons. I'll do the better one first.
That's a good question.
We can plead in the alternative, and the officer might have been retaliating because he just didn't like being recorded, and that saying it was because it was live streaming was a pretext.
Okay, go to the next one.
The next.
That's bad if that was the best one.
That's the.
You shouldn't have given away the order on the front end, because
Well,
after
the
that
other
one,
one
you
is-
should say, now this is my better
Oh, and
one.
then of course, like the coup de grace, the greatest one would be that live streaming has two components. It has a recording component and it has a streaming component. And we don't know which aspect of live streaming was the reason that so he was broadcasting to a remote server that was recording what was happening. And so that would be the other way, that it was broken out as live streaming is actually recording and then broadcasting in real time.
Thank you, Mr. It's very interesting. We've extended the argument somewhat. Appreciated the arguments. It's an interesting case. Our practice would be to come down and shake your hands and thank you for these arguments. And it's an important practice, I think, but we're still following the COVID protocols. And so we'll pass on that this time. When you come back, we'll shake your hands again. We'll proceed on to the next case. Perez versus Becerra, and Mr. Bonk, whenever you're ready, we'll hear from you.
Thank you, Your Honors. May it please the court. In this case, plaintiffs were denied for years their due process right to a timely hearing following deprivation of a property interest by their employer, the Department of Health and Human Services. I'd like to address two main points this morning. First, that those delays are fairly traceable to HHS as its actions had a predictable effect in dramatically delaying hearings in plaintiffs' matters. And second, that this is the correct avenue, this avenue that plaintiffs have pursued filing through the district court, the correct avenue to address this violation and seek a remedy for the violation of plaintiffs' due process rights.
Can you start instead by addressing why the case isn't moot, given the appointment of a full board now and the blessing, if you would, of the ALJs?
Yes, Your Honor, absolutely. The issue here is that the due process violation has already occurred. The due process violation here is the extraordinary delay that plaintiffs faced. The relief sought here is not a hearing on these matters finally years and years and years later at some point in time in the future, because named plaintiffs still have not had a hearing. The matters still remain open at the MSPB. The due process violation already occurred. What we're now seeking is a remedy for that already occurred due process violation.
But the remedy that we can't give you substantive relief, right? So you've alleged a procedural violation. We can provide you procedural relief, right? We might be able to enjoin HHS from doing certain things, but we can't actually grant you back pay for a procedural violation. It doesn't strike me.
So Judge, I believe that is the remedy for procedural violation, and there's quite a bit of case law.
Yeah, help me understand how, if you allege a procedural violation, that in the context of the Civil Service Reform Act, that this court can say you get back pay.
Certainly. So, and Judge, admittedly, a lot of the case law on this is at the MSPB, the Merit Systems Protection Board, and the Federal Circuit, where a lot of these matters end up instead. But with that, cases like Ward, Stone, even to some extent back to Loudermill there, this is a situation where—
That's because they can grant, I mean, they can do lots of things, right? Like they have statutory authority to give you back pay, right? So I get that. But the question is whether we or our district court has the authority outside of the Civil Service Reform Act to say, hey, this organization, you know, didn't dot their I's and cross their T's, or provided no process at all. How do we have a authority to grant substantive relief as opposed to procedural relief, right? We might be able to say, you know, HHS, stop filing these motions, or, you know, board, have a hearing, ALJ, have a hearing. But I don't understand how we can grant you substantive relief for your mere procedural.
We probably don't even have jurisdiction. I mean, for substantive relief, you probably have to have the Federal Circuit, right?
So it's a very interesting question, Judge. And the jurisdiction—
I think it's sort of part of the relief that the question about relief. What kind of relief can we grant? You've brought it here basically for due process violation, I suppose.
That's correct, Judge. And I think hopefully this answers both of your questions on that issue, where we don't think we could bring this to the Federal Circuit. We don't think the Federal Circuit does have jurisdiction. I know that defendants have raised the possibility of raising this to the Federal Circuit instead, this claim, on
that issue, I think you well could have appealed to the Federal Circuit if you've gone, say, 4 times or 5 times on the 5th order, appeal it, it's a little bit like the injunction that's not acted on. We take those cases and conclude that the injunction is in effect denied. And I think if you appealed one of those orders to the Federal Circuit, the 5th one, say, the Federal Circuit would say, well, at this point, your relief has been denied because effectively none of the procedure has been put in place. But that's neither here nor there. I think the government's main argument is the fact that HHS filed a motion does not determine how the ALJ rules, and that's sort of holding the person who files a motion responsible for the decision of a judge. They say that's hardly standing. To sue HHS is hardly meaningful in any way. Anyway, this case has got what? It's got standing, whether you have a relief, it's got mootness questions. It's an interesting mix.
Certainly, Judge, and you know, perhaps to this standing issue, going back to your question there, I think what we're looking at here is obviously for standing, there doesn't need to just be proximate causation, right? And we think that what we're looking at here is kind of a predictable effect situation for standing, like the Supreme Court addressed in 2019 in Department of Commerce. Obviously, there's not a pure overlap there, but I think it stands for an important proposition that for purposes of standing, plaintiffs don't need to establish that it's solely HHS's fault. There can be a situation.
No, but you know, it's analogous, I think, to suing the person who files a motion in federal court for responsibility for the fact that the court granted the relief. The court made its own decision to grant the relief, and so you're going to sue the attorney for asking the court to grant the relief?
And friendly hypothetical, when they're plainly correct, when the motion is legally correct, right? I mean, that's the oddity you've got here, right? It's like sometimes we might imagine a malicious motion or something. Maybe we think there's some sanctional action, but I mean, they're filing a motion that's right.
So, well, I will disagree on that, Judge. I don't think their argument on Lucia is in fact correct. But of course, the merits are not before this court. No, I do. I think there are deficiencies there. But to that point, we're not looking at a situation where I think this goes beyond a situation where you can assert that the briefing is simply part of the vigorous defense that the agency is raising, right? Part of their briefings, part of their filings here. This is a concerted effort over nearly 100 cases of current and former HHS employees where those briefs were filed. And significant—
To not have adjudications that will all ultimately be vacated because they're done by an individual who lacks the authority under law.
And that's the issue.
I mean, that can be a concerted effort, right? I mean, like, why is that a bad thing? All right, so you may want to say that this is different, but assume for a minute I don't buy that. What's wrong with being a concerted effort to ensure that we're not wasting our time on adjudications that are, like, by their nature, like, invalid?
And I think that actually goes to the more on the merits aspect of this, of does this constitute, does this delay rise to the level of constitutional due process violation? What you're raising there, Judge, I think goes into the malfactored analysis. That is part of the justification for the delay and evaluating what length of time of delay is reasonable under the circumstances. That's where that fits into the larger
Right, but
framework.
you want to blame, I mean, you know, there's plenty of blame to go around here, but it's hard to see why the blame is HHS's for saying, listen, we're literally just trying to follow the law.
I understand, Judge, and here we're not asserting that HHS is solely at fault, right? And as you said, and I think the district court recognized this. There's some finger pointing going on here. There's a lot of issues that gave rise to the situation. It's a fairly unique situation.
You know, we had it's I don't know if it's totally analogous, but we've had these cases as the D.C. Circuit has, where hospitals wanting reimbursement from Medicare, Medicaid, have had a backlog of something like 18 years, and the answer was there was not insufficient funding to have people to review all these things, and eventually Congress did it. But these were allegations of due process violations, and really what you're addressing at bottom line, I think, is an address against bureaucracy, the failures of bureaucracy. I mean, your people have been inappropriately dealt with. There's no question about it. It's a very sympathetic situation. But we have a bureaucracy that has failed for whatever reason and caused some delay. The question is, what do we do? I mean, we can't direct Congress to fund. We can't direct this. Everybody's sort of come to that conclusion. We're the third branch, and this is a failure of, well, this particular failure was a little different failure. It was the appointments clause, but, and the result is the bureaucracy got gummed up and delayed. But I do believe you had more direct remedies, and the question is suing HHS is so indirect. HHS is trying to make do with the cards it's dealt, and it did the best they thought it could under the Lucy opinion, whatever it was, on the judges. And the real problem was, I guess some of the delay was the failure to appoint a board, right?
In part, Judge, and I think
Political question there.
so part of what we're looking at here, though, is this issue of were there other avenues, were there other direct avenues? And I think the Federal Circuit has indicated to us that it wouldn't be able to review such an appeal.
They can't review an order that's without prejudice, like the initial order. And they would send that back. There's no doubt about that. But there comes a point when that's done so many times that you can make a very credible argument to the Federal Circuit and say it's the same principle that when a district court judge doesn't act on an injunction and it goes on for 18 months and he hasn't acted on the injunction, we've entertained appeals from that even though there's no final judgment. And the statute says any order granting or denying an injunction, and of course the district court is neither granted nor denied. Your argument would be they have to take an appeal from a final order, but de facto couldn't be more final. I've been waiting years for this, and they may buy that. But the other avenue could have been, the government suggests, could have been a mandamus action too.
And to that point, I don't think mandamus is actually available here. And this
Maybe not. It may not be, but because mandamus circumvents a procedure that's already in place. That's the difficulty with mandamus.
Quite certainly. And that's what we're looking at here is that in the Jadov case where the Federal Circuit addressed some of this, the petitioner there did not have these same constitutional claims that plaintiffs do.
But the best we could do, I suppose, if HHS was responsible, we could tell them don't file those motions, and where does that leave you?
So if HHS files, and here's some of the
We
issues.
couldn't adjudicate the claims.
Before which form?
They're seeking pay. Your clients are. This is a procedural case, and you come before us and say this practice violates due process. If we agree with you, we tell HHS to stop filing the motions. That's all they've been doing is filing the motions, right?
So they have been filing motions.
That's the conduct that they
That's correct.
engaged in. So we tell them to stop.
Well, and I think in part what we have to look at here, and again, this goes to a bit to my earlier comment on what's the process due here. The process due generally for these types of procedural due process violations is a new constitutionally correct proceeding. And that's where we get about.
Right, but have they since we have a full board and the ALJs have now been blessed, have they filed motions since then? Why would we think they're filing motions today? But we don't enter injunctions to do something that you're not doing, right? Like that's not what we do. And so I would be shocked to learn, I'm gonna ask your colleague in a minute, but I'll ask you too. Do we have any reason to think that today HHS is filing these hundreds and thousands of motions that they used to file?
I don't think quite that many ever, Judge, but no, I don't believe that they are, in fact, still filing
Right,
those.
because for the very point that like the case is now moot, right? Because you have that access, whatever access it was, HHS is no longer standing in your way. There may be other problems, right? There's a line, and I get those, but you've only sued one organization, right? And so we can only look at like what they've done, right? You might have, I mean, you don't really, but in theory, you might have claims against the president or the Senate or somebody else who mucked up the appointments. But like HHS has only done one thing, and that's file a motion.
So again, the due process violation has already occurred. So we're not kind of seeking to preempt the violation of due process. This has already occurred, and so there's no benefit really to, as you stated, a plaintiff seeking instruction to defendants to stop doing something that they've already stopped doing. This is all in the past here at this point. At this point, what we're looking at is HHS having taken these individuals' property, taken this property interest by firing them, by demoting them, implicating this property interest, and these individuals.
See, on that issue, we don't have jurisdiction. We cannot restore money, and the whole process is taken from us. The best you can do is to allege HHS did something wrong that can correct a process. But the only conduct that HHS engaged in was to file these motions. And so now the question is, what relief would you have? And I'm trying to look and see what you asked here in your complaint. But what relief did you ask us to impose against HHS?
As we're stating here, Judge, the declaratory relief of violation of the due process, and so ultimately a rescission of these actions that HHS has imposed. These claims, this appeal stems from.
Okay, so we tell HHS not to file them, and then retroactively you want us to take all those decisions made by the ALJs. You want us to reverse those somehow?
No, Judge, and I think that's what the issue is here. There are no ALJ decisions because these matters have been.
Well,
So the decision was to dismiss. The ALJ made a decision to dismiss, right?
without prejudice.
Well, the dismissals without prejudice, correct. So what I'm referring to is a rescission of the personnel actions, the terminations, the suspensions here. And,
We don't have the substantive cases before us. You're just addressing a violation of due process committed by HHS. They didn't address for them to get money, they're going to have to go through the system and then go to the federal circuit, right?
the normal process would be that avenue, yes, Judge. And I see my time has concluded.
Yeah, no, you can respond to that if you wish. It's
And so I think my response to that, Judge, is that the remedy here is this reversal, is this restoration. The first step in getting this restoration, this new procedurally correct, constitutionally correct procedure to correct these personnel actions that HHS took, which ultimately have resulted in this due process violation, is a rescission reversal of those personnel actions, reversal of the termination, reversal of the demotions.
Are they before us? Were they appealed to us? You basically appealed, you filed an action challenging HHS's filing of motions. So how did we somehow get jurisdiction over your claims for pay?
Because again, Judge, is our position that the remedy for these due process violations, these procedural due process violations, being as though they implicate.
So we're going to just disrupt the whole process Congress created, and we're going to take a direct review of their cases and give them relief.
And unfortunately, it's a situation, perhaps a unique situation, Judge, where that Congress created by, or the process created by statute was non-functioning for a time, and in that delay, the plaintiffs were provided only that avenue to seek relief.
We'd be creating a lot of interesting powers in our own behalf. All right, you have rebuttal. Let's hear the other side. Mr. Salzman.
Thank you, Your Honor, and may it please the Court, Joshua Salzman for HHS. I'd like to begin with Judge Niemeyer's observation that this case seems to have a lot in it, and jurisdiction and mootness and standing, and I'd posit that each of those offers an independent basis for affirmance here, and an independent flaw with the pleadings here. I'll begin by emphasizing two. One is the traceability holding that the district court resolved this case on, and also on the jurisdiction holding that I think has rightly been, or the jurisdictional question that has rightly been a focus of the discussion so far. But before I get into those, I'd like to refer the court to page 16 of the joint appendix. That's the prayer for relief in the complaint, because I think it'll help clarify exactly what this case is about and not about. There's a request there for declaratory relief. I think that is unquestionably moot at this point. Because the board's now appointed and has ratified the appointments of the ALJs, there's no prospective issue about HHS filing these motions. Then if you look at JA 16, what the rest of this is about is money. It's about substantive relief. It's trying to get reinstatement and back pay. And as I think I heard from Judge Niemeyer, that's a blatant end run around the processes set up through the Civil Services Reform Act. This is not about getting them the timely adjudications. This isn't about
I
process.
posed it as a question. It was a loaded question, but that was just a question.
Well,
But it seems
regardless of the
somewhat
intent,
obvious.
of course, and I don't want to presume to speak for what Your Honor actually thinks on that question, but I would suggest that that question is highlighting an important deficiency here in this case, that the way to get substantive relief, to get back pay and reinstatement, isn't to file a due process suit in the District of Maryland outside of the procedures that Congress established. My colleague suggested that almost as if it was happenstance, that the case law about what happens in due process in these cases
Well, I
tends to be in the
understand
Federal
his
Circuit.
relief. I just looked at his relief, and he wants a declaratory judgment, but he basically wants us to order back pay. And it seems to me that is like a mandamus. He's asking us, as a irrelevant court in the process established, to go back and give these guys back pay because the HHS didn't give them due process.
I think that's probably the way they would describe it, but I don't think the district court had jurisdiction to provide that kind of substantive relief under Elgin and under the Civil Services Reform Act. There were proper mechanisms to use, including appeal to the Federal Circuit as a way to litigate these issues. But in terms of getting the substantive relief, simply by attaching a constitutional label to your claim is not a means, as the Supreme Court made clear in Elgin, of circumventing the substantive procedures Congress laid out in the CSRA. I'd also like to spend a minute on the traceability argument, because I do think that that's a separate, independent flaw, and it is actually the basis on which the district court ruled here. Here, they allege that HHS did nothing more than made an argument, and as Judge Richardson observed before, a very meritorious argument to a neutral adjudicator, who then exercised a discretionary docket management tool that led to the delay in resolution of plaintiff's claims. That doesn't have the necessary link of causation. When you make an argument to a court or an adjudicator, that fails the traceability test. And in particular, I'd refer the court to, there's a case cited in our brief called Tarani versus Ray from the Sixth Circuit. And in describing the principle that the intervening act of a third party can break the chain of causation and prevent the demonstration of traceability, it actually uses as a paradigmatic example of when that will be true, when a litigant makes an argument to a court. And that's, in fact, exactly the circumstance we have here.
Of course, there was a 100% success rate in making these motions, right?
There was, Your Honor. But I think that speaks to the fact that this was a serious argument and a serious defect being highlighted by HHS.
But it wasn't being made by other agencies, nor was it being raised sua sponte, was it?
It was not being raised sua sponte. Other agencies did not make that argument. I can't speak categorically to whether any other agencies raised this argument, but certainly not all did.
Right, but what did happen is that when the agencies didn't raise it and the claimant lost before the ALJ, we then vacated those decisions, like in the Social Security context. So it became sort of a one-way story, right? So if the claimant won, they won, but the claimant lost, then they could come to the federal courts, and we vacated all those decisions because the ALJs were not validly appointed.
That absolutely happened in the Social Security context. This court had the Probst case, and then it went up to the Supreme Court as Carr versus Saul. The Federal Circuit right now is still considering the McIntosh case, which is referenced in our briefs, where a litigant against the Department of Veterans Affairs tried exactly the maneuver that Your Honor is suggesting, litigated the case before the administrative judge at the MSPB, lost on the merits, and then raised an appointments clause challenge for the first time in court. So yes, that is absolutely a valid concern for the agencies to have under these circumstances.
And the concern there is that based on exhaustion, you don't even have to raise it at the ALJ level, depending on the statute and lots of different things, but there may not be issue exhaustion that's required in order to raise it, on the back end. And so an agency might have really good reason to say, no, we want these done by an ALJ who's properly appointed or properly blessed after the fact, as we now have.
Yes, that's a completely valid concern. I want to be careful here because we are arguing in McIntosh that the forfeiture rules don't carry over, that administrative forfeiture principles do apply to,
I understand, but it's not
to the MSPB, but it's an open question, and there's absolutely legitimate cause for concern there. I'm happy to address any other questions the panel may have for me, but
All right. Thank you, Mr. Salzman. Mr.
thank you.
Pond?
Thank you, Your Honors. Just to address a few points raised by my colleague there. On the traceability issue here, Your Honors are correct in the sense that these matters were not raised sua sponte. And this goes to that traceability connection, the predictable outcome here. The motions filed by HHS specifically sought a dismissal until appointment of a new board here. And this had no end in sight at the time. There was no way to predict as to when this would occur. So these motions are...
But dismissal until the appointment of a new board, but not for the board's sake. The point of that was dismissal until we've got ALJs that have been properly appointed.
Correct, Your Honor. But here, but for HHS filing these motions, these matters proceeded. These matters continued. The MSPB did not stop processing these. The MSPB did not raise this Lucia issue sua sponte. Business proceeded as usual. But for HHS stepping in and raising these motions. And here the problem is HHS filing these motions, raising this issue with the appointments situation at the MSPB, effectively barricaded off this one avenue to get this post-deprivation relief, this post-deprivation hearing afforded to plaintiffs. It's a due process right. It's also a statutory right on this avenue through the MSPB. But the HHS motions cordon that off, and so they have nowhere else to go. And so
How long would be, where do you sort of draw the line on how long is too long, right? So we have some administrative proceedings and indeed some court proceedings that sometimes take a long time. And that's not always the fault of the administrative or judicial officer. Sometimes we've just got a volume problem, right? And so you might imagine in some Social Security settings or in some, particular visa context, they're extraordinarily long delays. Black lung cases.
And I think some of the case law on this issue addresses that issue, and there's no clear bright line here. Rather, what we're looking at is somewhat of a reasonable evaluation within this Malin context of application of the Malin factors. How long is too long?
Right, but if that's true, all right, so accept that. How long is too long? And HHS says, right, why are we being held with the expectation that the president and the Senate are going to take forever to figure this out, right? Like they just want a competent adjudicator, and they're not called upon to try to guess how long it's going to take to get a properly appointed board, right? Their job is to just try to figure out the case in front of them and say, listen, we don't want to do this any longer than we have to, but we need a properly appointed judge to decide it.
But at the end of the day, due process was owed to these plaintiffs. They had a due process right to a timely post-deprivation hearing, and
I think that begs the question, a due process violation, because the question was how long of a delay implicates due process. And it seems to me it may depend a lot on context.
It
but,
does.
Litigation, even in the outside of the administrative process, litigation often takes 5-6 years in cases.
And so there's an important distinction on that, Judge, I think. And here, in a number of the cases that this court and others have looked at for this evaluation, I think in the Timms case, for example, the pertinent period of delay that this court looked at for how long was too long for due process violation only ended up being about 4 months from the time of the request for hearing until the hearing was held. There was a great deal more delay on that. But the distinction here is there was a lot of delay that could probably be tagged on the petitioner or the appellant in that circumstance. Same as in some other matters. Malin, I think it itself was only 90 days, so not a terribly long delay. But I think some of the distinction that this court has looked at in its decisions is how much that delay is at fault of the plaintiffs, and looking at the Supreme Court finding 9 months not unconstitutionally lengthy in Loudermill as a delay. Well, this goes far beyond that. We're dealing with years. We're not dealing with 90 days as in Malin. We're not dealing with 4 months in Tim's. We're dealing with years of waiting.
Other administrative cases we have, we're talking about years. We were talking about 18 years, I think, in the Medicare, Medicaid reimbursement. And we talk in black lung, these cases typically are 8 to 12 years old. I mean,
But I think there's still a distinction.
People are denied their benefits, at least that's their position. And
I think there's still a distinction here, Judge, because in some of these other cases, I mean, we litigate, things take far longer than they should sometimes. But again, things are processing. There is movement in the cases. Here, the problem is following these motions, case processing.
The HHS was trying to file motions to establish or restore process, and it fully expected process to be restored. And in fact, proof of the pudding is it has been restored.
Well, but Judge, I think that the effect of these motions, there was no processing on these cases following these motions. HHS would file these motions, processing would freeze, everything would stop, and it would be put in this perpetual cycle for all of these plaintiffs, nearly 100, over and over again, dismissal without prejudice, automatic restatement, cycled again.
It's unacceptable, there's no question about it, but the question is, what kind of expectations does somebody come into a system with? I mean, we have a adjudicatory system, and we try to do our best and make things speedy trials and speedy hearings, and Congress often builds in automatic appeal periods if somebody doesn't decide. There's a lot of agencies where if a particular level doesn't decide it, the person can appeal in 180 days or whatever to the next level. And if the secretary doesn't decide, then it's deemed decided and you can go into court. But this, what are we talking about, a few years here where we had this political problem of not having an adjudicatory person or persons in place.
And Judge, if I may address, I see my time has expired
Yeah,
here.
go ahead and respond to that.
Certainly, and I think here, there could have been some alternative process. The existing system was frozen. The MSPB avenue was open where agencies did not file these motions. HHS filed this motion to freeze out the MSPB process. Plaintiffs were still owed some avenue to be provided this post-deprivation hearing. There was no alternative process offered. They were wholly locked into this.
That's all up to Congress, isn't it? What process is provided?
By statute, certainly.
Yeah.
But I think that I don't know that HHS or the government made any efforts to process this. At the end of the day, I don't know that efforts were made to accommodate the due process rights of these plaintiffs.
Okay, thank you very much.
Thank you, Judge.
All right, we would come down and greet counsel. As I've mentioned before, we're bypassing that because of our protocol now, but we're not abandoning it. This is a virtual handshakes, and thanks for your arguments. We'll take a short recess. Next case we'll hear is Robinson versus Priority Automotive. And Ms. Brown, I guess we'll hear from you first, right?
That is correct. Good morning. Still morning. Good morning, Your Honors.
Is it good morning? Yes, ma'am. It's
Yes,
still good morning.
it is still good morning. May it please the court, my name is Alicia Brown, and I represent the appellants and plaintiffs, plaintiffs in this matter. Your Honor, this is a case where we believe the lower court misapplied the Rule 56 standard and ultimately weighed the evidence that was brought before the court as opposed to determining whether or not there was a material issue of fact in dispute. And so we're here today, one, because the lower court resolved those material issues of fact that should have, in fact, been resolved by a jury, and two, because the lower court did not view the facts in a light most favorable to the appellants as the non-moving parties. I know Your Honors are very familiar with the facts of this particular case, but I typically would not go into the facts of the case. However, I think going along with our argument that the lower court resolved the issues of fact, I think reviewing the factual and procedural background that's actually noted in the court's order dated July 8th, 2021 is very helpful for the court in understanding how the judge or the lower court misapplied the Rule 56 standard in this case. First, Your Honor, one of the things noted by the court on the second page of the order is that during his brief introductory comments, Mr. Beckley, who is the general manager that is being complained of at this car dealership, instructed all existing priority employees to continue performing their same job duties. This is an important fact that was included inside of the lower court's order, but this is not any fact that was offered by my clients or by any of the affidavits or declarations that were submitted by my clients. And it also states that Mr. Robinson, one of the appellants, did not personally meet Mr. Beckley or receive individual instructions from him. We believe that the judge or the court in this particular case came to that factual finding when my clients presented a plethora of evidence that demonstrates that that is not what in fact occurred. If you take a look at the record, there are a number of, there's a lot of evidence that demonstrates that my clients tried to meet with Mr. Beckley, who was the general manager, to determine what their position would be since he had taken over.
Wait, I just want to make sure I understand your argument, because you said the lower court magistrate judge said that there was no meeting, and then you respond by saying there's evidence that my clients tried to meet, which doesn't put in the issue the fact that there was no meeting, right? I mean, you can try to have a meeting, I can try to do lots of things, but the question of whether I did them is like a separate question, right?
Sure. So just by way of background, and thank you for that, Your Honor, there was when Mr. Beckley came in as general manager, there was a meeting held with the entire store.
Right.
Okay. As my clients who were sales managers, when he came on, were trying to continue to engage in their activity as sales managers, there were salesmen telling them, oh, Beckley told us not to bring any deals to you any longer. So when my clients are receiving this message from the salesmen, they are then trying to communicate directly with Mr. Beckley to say, hey, what is going on? Are we being demoted from sales managers or not? And Mr. Beckley is refusing to speak with them, shooing them away as they're trying to figure out what is our position. Are we being demoted? Are we still sales managers, or are we salesmen at
I'm
this
sorry
point?
to interrupt, but I just wanted to go back to your first statement, which I thought was not so much about the meeting, but about whether or not everyone was going to continue with the jobs they had. In other words, that there was an understanding that he was coming in and everyone was going to keep doing for the time being what they were doing before. Is that what you first asserted? Am I correct?
I'm asserting that my clients my clients do not recall that statement ever being made, and that is not evidence that was presented by my clients.
Right, and then it moved into your clients wanted to meet with Mr. Beckley in those first days, but didn't end up having the opportunity to do so, either because Mr. Beckley was too busy or because he refused to. Is that right?
Because he refused to. That is correct, Your Honor.
But again, as Judge Richardson said, are those things necessarily in conflict? In other words, is the fact that everyone continued to do the same job not possible and consistent with the two of them not having that direct or personal communication, but it being factually accurate that everyone was expected to do the same job?
It is, it is inconsistent, Your Honor, because when so if he did make the statement, we're arguing he didn't, but if he did make the statement that all folks should continue on working, their jobs or in their positions, and if my clients were to try to do that, the evidence that we've presented, not only from the appellants, but also from a number of employees who worked there, was that the employees were told that they could no longer take the sales to the appellants in order to close out the sales as sales managers. So the issue is, how can you say, oh, continue on being sales managers for all of the sales managers, but yet you're telling the salesmen not to take any of the sales to the managers to finalize those deals, which is the primary function and duties and responsibility of the sales managers.
Yeah, just so I want to be sure that I look at the record and I look at the right places. I just want to be clear, this continue with their jobs. You say that evidence didn't come from my clients, and then there's some reference to my clients don't recall that, which is not to say it didn't happen. It's just that they don't have a independent recollection one way or the other. But where am I looking in the record to see where your evidence puts at issue whether that statement, continue with their jobs, or the effect of that statement was made?
Sure.
You see what I'm saying? Like, that's the finding. I want to see what in the record you want me to look at to suggest that that didn't happen, or that there's a dispute of fact about that question.
Yes, Your Honor. If you look at the declaration of Quentin Alston, it is on page 1124 of the record, paragraphs 7 through 9. He is specifically stating that he was told by Mr. Beckley not to take any sales, only as it pertained to the appellants in this case.
Right, but that doesn't undermine the allegation or the factual finding or the fact, undisputed fact, as the magistrate judge found, that everyone was told that they would continue with their jobs.
I think what undermines that fact is even if we were to assume that fact were true.
Okay, but all right. Do you have anything in the record you want me to look at to suggest that that statement wasn't made?
No, Your Honor.
Okay, all right. I understand now. I'm sorry. I misunderstood. I thought you were saying that there was no evidence that that statement was made or that was a disputed fact. That's not disputed. What you're saying is, yes, they were told to continue their jobs, but their jobs were undermined by the statement that some salesmen were not permitted to take sales to your clients.
That is correct.
I understood that argument. I thought you were making a different one. Please go ahead.
My apologies, Your Honor. And there are a number of different factual statements that are made in the actual order by the lower court that are actually incorrect. For instance, the judge found that plaintiffs alleged that several items from their desks had been missing following the reorganization of the sales floor. And what's important is that the court found that the plaintiffs did not recover any of the missing items, and there's no evidence that they made any attempt to do so. That is absolutely contrary to the evidence that was introduced by my clients in this case. Not only did they testify that their belongings had been thrown away, but there is testimony on pages 839, 901, and 925 of the record that clearly demonstrate that my clients were actively trying to locate their items that were randomly thrown away by Mr. Beckley when he became general manager, and they were told that the items were out in the dumpster and that they could go out and get them. Now, obviously, no one's going to climb into a dumpster outside, but I do believe
it depends on what it is, right? I mean, I'd climb in a dumpster for something, right? I mean, I got a bunch of little girls. Somebody threw one in, I'd go in after her.
I would go
right? Like, I
after.
mean, I got a nice enough watch. Somebody threw it in. I don't have nice watches, but if I did and somebody threw it in, I'd go in after it. Right? I mean, that might be unpleasant, but
I think it would be for a reasonable jury to decide whether or not, it was, if there was an actual effort on behalf of my clients to actually go and retrieve, whether if it was reasonable for them to go and retrieve their efforts. And so the point of me stating that, Your Honor, is the lower court is saying there is no evidence that there was any attempt for my clients to do this, when there's actually very clear evidence to the contrary that they did make attempts to do this. And they were told that it was thrown in the garbage by Beckley, and that they could go out and fetch it out of the dumpster if they like to do so. What's even more shocking about some of the factual findings by the lower court, and again, the biggest thing, and I'm going to wrap this part up in a second, but the major thing is the lower court has made these factual findings and they have weighed the evidence and we believe that under the circumstances where a Rule 56 motion was filed, that is improper. And it's stated in the factual findings by the lower court, there's no evidence that Beckley specifically instructed other employees to cease dealing with plaintiffs. That is absolutely not true and contrary to the facts that are offered by my clients. And again,
Let me ask you something. I thought you were going to get a little bit more to the relevant facts. It seems to me what this record shows is that Mr. Beckley came down on short notice from another dealership owned by the same owner to fix this one up. And he came down and found it in pretty sad shape. Boxes were around, sales were being conducted from the remotely and not, he wanted to change the location of sales. He wanted to clean the place up. He wanted to shape it up. And he was going around treating people roughly and coarsely. And during the course of all of this, you complain about a reference a reference to a group that contained African Americans or blacks as thugs, and that during the sales meeting he says, "Let's make priority great again." The only other statement that I saw implicating the Title VII was being on the right side as opposed to the white side, but that turns out to be about triple, quadruple hearsay, and the person who said it actually denies that. We don't really need to resolve that because that wasn't direct, and he didn't even hear it. He was told it remotely. So we really are focusing on the fact that Beckley, and he explained, he probably used the wrong words, thugs, and make America great, and he says, he didn't know that offended, but he agrees he could have used some other phrase because your clients thought "Make America Great Again" was a racist, and that therefore "Make Priority Great Again" would be racist. That's the case. And so the question is, regardless of who struck John and whether he was demoted or whether he was not demoted, and there was a lot of confusion as to that. Beckley brought down some of his own people. He was going to install them in some places, and he was trying to shape the whole thing up. And there was a little bit of a rebellion by your clients. They didn't want to move where their sales position was, but that's not an issue. None of these things are really an issue. The issue is whether all of this conduct was racially driven, sufficient to satisfy Title VII. And I thought that's really where we're at in this case, isn't it?
That is, Your Honor. And I want to note that as it pertains to determining whether or not a reasonable jury can find that the conduct was racially driven, this court has held that the circumstances that the evidence has to be...
find a severe and pervasive atmosphere, and that decisions were made based on race and that type of thing. You allege a demotion because sales weren't being brought to him. That was a de facto demotion, I guess, because they weren't approving sales as sales managers would.
Well, Your Honor, I want to note for the court the importance of the totality of the circumstances.
Well, that's what I'm looking at. That's what I think is the important part, is to look at the whole circumstances of this, 5-day engagement with Beckley coming down and trying to put the dealership in some kind of order. He was a little bit of a bull in a china shop. I mean, he came down and he romped around, and every time he was called to task on, he says, well, I'm sorry, I didn't really mean this or that. But the question is, we're not talking about whether people were treated fairly or whether he acted appropriately. We're talking about whether there was a Title VII violation.
And Your Honor, respectfully, I see that my time is winding down. May I answer your question? Okay, yes, Your Honor. Well, first, it is in dispute as to whether or not the store was doing poorly. The previous general manager stated that it wasn't. But I want to note that it's not just simply about the thug comment, right? We know that that's that's racially motivated because he was only referring to a group of black employees. We also know that Kyle Vasquez.
That group actually included a white or two, didn't it?
It did not.
Did not, just all blacks?
It was black. It was 3 black males and it was 1 Latino male. When Beckley saw him over there, he called him and said, "Hey, you probably shouldn't hang out with those thugs," or something along those lines. But it's not just the thug comment, Your Honor. It's the fact that Mr. Beckley only told the salesmen not to take their sales to the only 2 black sales managers that were there. And yes, Beckley brought in his team, but what's important
Were they
is
the only
that
two that didn't move when Beckley reorganized the space?
there was, so my clients didn't just not move. Everything was removed except for my clients' desk areas. And so they have their desk area, and then there's this like huge open area, sales area, and then the other sales managers are situated over there with the salespersons, while my client's desk are situated in the front of the dealership where they had previously been situated. And so when you're closing deals, you know, you'll see in the record when you're closing those deals, the salesmen will go to the sales managers. Well, if all of the other sales managers are across the dealership, and then if also the general manager himself is saying, hey, don't go to those 2 sitting over there, go to the folks over there. And if the only difference between my clients and if the only difference between, but again, understanding the totality of the circumstances, the plaintiffs in this case were the only 2 black.
I asked the first question and you, that's okay. All right. I'm sorry. You're over time. I think there was 2 different answers there, but that's okay. You've got some time on rebuttal, I think.
Thank you, Your Honor.
Okay, thank you, Ms. Brown. We'll hear further from you. Mr. Tower.
May it please the court, Your Honors, King Tower, and I'm here today with my colleagues Leah Stiegler and Rebecca Kolog. We are here because the district court correctly decided that the specific facts requirement that the plaintiff was under at the summary judgment stage to come forward and show that a rational trier of fact could return a verdict in the plaintiff's favor was not met in this case. And again, as the judge found, the admissible evidence doesn't satisfy this standard. Quite a bit of the evidence that's referred to by appellants in this case is hearsay, and it's we had discovery in this case, and it's plaintiff's obligation to obtain evidence from the witnesses who claim to have heard from Mr. Beckley at least, and so we have 2nd and 3rd degree hearsay with regard to things like people being told that they should not take sales to the plaintiffs in this case. But be that as it may,
so is your position the statement that we were told not to take sales to these plaintiffs, that's only hearsay?
That's right, because it is presented as employees who allegedly came to the plaintiffs. The plaintiffs are testifying about this, and what these employees are claiming is what they were in turn told by another.
So there's no evidence in the record of an employee that was told that by Mr. Beckley?
The employees themselves, I'm not aware of evidence that anyone directly says I was told this by Mr. Beckley. Kyle Vasquez did testify that he was told that the sales area is moving to this new tower, and this is where the sales will be conducted from now on in this more open area, which was...
What is a tower?
It's just a large desk, as I understand it. It's just the place where the customers some of the customers were doing service nearby. It was a more open area, and so this tower was sort of the central place where the sales associates and the sales managers could.
Is it actually a tower? Vertical?
To be honest with you, Your Honor, I'm not sure if it's a tower exactly or just a large desk or counter, but that's my understanding of it.
Well, counsel, I don't mean to put you on the spot, but what about, as your colleague mentioned, JA 1124, paragraph 7, which is the declaration of Quentin Alston, who makes reference to Beckley instructing him and the other salesmen to take any deals to new managers that he brought with him. And then the sentence is, it was understood that sales were to no longer be taken to Chris and Kenny.
Well, and I guess, Your Honor, I think we do acknowledge that that declaration was submitted. I think that there is a dispute, I guess, to the extent we are talking about was anyone told by implication not to use the area where Mr. Hall and Mr. Robinson had previously been sitting, and that was to be interpreted as don't take sales to them as individuals anymore.
Did you depose Mr. Alston?
We did not. And so the only evidence we have that the sales were directed to not be taken to Mr. Hall and Mr. Robinson as individuals comes from their own testimony that they were told this by other individuals, which is inadmissible, of course, in this case. And Your Honors, there.
Can you help me understand it? Your colleague was talking a little bit about why it was that that the plaintiffs here did not move to the quote unquote tower. And I couldn't tell. At one instance, it seemed like they refused, and in another instance, it seemed like she was saying they were not permitted. Can you talk to me about where I look in the record to see either side of that coin?
Right. Well, Your Honor, there was a declaration submitted from Mr. Gathers, who's an African-American sales employee of Priority at the time, who testified that the plaintiffs were choosing to apparently remain at these desks where they had been. I'm not familiar with any evidence that they were directed or forbidden from moving to the new area. So I think the testimony from Mr. Gathers in any event was that they were even sitting in their cars or sitting at their former area and were just sort of waiting to see what would happen. And as Judge Niemeyer mentioned, this was a sort of chaotic period where the new general manager is trying to evaluate everyone and whether they are going to stay on the team. And he did tell the employees to just keep doing what you're doing. And the record at 488 is where Mr. Robinson says that he was directly told to keep doing what you're doing. That happens to be close to the record where Mr. Hall, I believe it is, on 486 said, when he's asked, did you make any attempt to try to locate where your belongings were, his answer was no. So you were asking about where that might be in the record as well. So I think Judge Niemeyer is correct that the district court correctly.
Help me understand why that. I mean, I know this is like the tail wagging the dog, right? But on the conversion claim, why does it matter that he made no effort to find the items? I mean, it just is a strict conversion question.
That's fair, Your Honor, and I think that had he done so, I guess there may have been some more evidence that these weren't unlawfully taken, that they were just missing. But I think it just goes to show that there's really not even evidence that would support that these items were taken in any sense, rather than just.
He's told they're in the trash, right? I mean, the implication is that someone put them in the trash, right? I mean, maybe he doesn't say someone put them in the trash, but if you say, "Where's my stuff?" It's in the trash. The clear implication is that someone put them in the trash.
It is, and of course that would also be hearsay evidence that the plaintiffs are attempting to rely on. But the fact that the plaintiffs made no effort to determine whether or not that's actually what happened or where these items were, it just goes to show that there's insufficient evidence to pursue their case on that grounds. So what we're left with, Your Honor.
Any evidence that linked, I suppose there was a general cleanup. I saw there was some criticism about the fact that boxes were lying around and the place was just generally unkempt. So Beckley comes in and tells employees, let's clean this place up. And so some 2 or 3 cleanup crew go and start throwing everything away, including the plaintiff's goods. Is that sufficient to hold the dealership responsible for conversion?
Well, as I understand it, Your Honor, the plaintiff's evidence that conversion occurred was that they had items on their desk and that they believed that Mr. Beckley himself had stayed late in the evening before and they showed up and these items were gone. And so for that reason, they say this must be conversion. But I'm not sure that is sufficient evidence to hold the dealership responsible in any event. That these are missing items, and so there's no reason to impanel a jury to determine whether or not a conversion has taken place if the plaintiffs can't point to specific facts that that jury could rely on to make that finding at trial.
Do you agree if we affirmed otherwise on the non-conversion claims that the district court would then face a question about exercising supplemental jurisdiction over any conversion question?
Correct, Your Honor. Would have to decide whether to remand. As you saw, this case was originally filed in state court, but in any event would have to decide whether to exercise that jurisdiction. And Your Honors, I think that the alleged comment referred to earlier about make priority grade again is clearly not actionable, as the district court found. And so at the end of the day, the gather's call where the plaintiffs claim that a phone call that was played to the sales associates was in some way intended to embarrass this employee, that's the evidence that they're relying on, and the district court correctly found that was not in any way indicative of any race-based intent or animus on the part of the dealership or Beckley. And so, the testimony that Mr. Vasquez said that Beckley told him not to hang out with those thugs was deemed to be insufficient to be severe or pervasive harassment, creating a hostile work environment. Remember, we're talking about a period of a total of 5 days before the plaintiffs voluntarily resigned. And so they try to assert that this was a constructive discharge, but clearly under the court standards, this is not going to meet that standard for workplace conditions that are so intolerable that a reasonable person would feel compelled to resign. And so for that reason, there cannot be a constructive discharge nor a hostile work environment claim here. In terms of a demotion, as was discussed with my colleague, the plaintiffs did claim to have been demoted. In fact, they said that they were told they were demoted, and then during discovery admitted that was not actually what happened, and that it was more of this, as Your Honor mentioned, sort of de facto, they were experiencing what they felt like were different job duties, I suppose. But the demotion claim also suffers from a lack of an adverse action, as well as any lack of any indication that this evaluation process, or I guess this potential that they might not be managers going forward, was based on Beckley's consideration of race. In fact, the undisputed testimony is that Beckley promoted multiple African-American managers, terminated multiple Caucasian managers, all in this exact same time frame as he was evaluating the talents and skills of the staff that he inherited. So the district court, again, correctly found that there was no unlawful demotion as well. There are a variety of negligence claims that have been advanced. Those that involve inherently intentional conduct, Your Honors, those fail in terms of trying to recapitulate as either general negligence or negligent infliction of emotional distress. The intentional infliction of emotional distress counts also fail, as the conduct here does not meet the standard for extreme and outrageous conduct. and the distress element is also not met there. And so the last count, in addition to the conversion and trespass to chattels, would be the negligent hiring, supervision, and so on, retention. Again, there's no evidence that Priority knew or should have known that Beckley was in some way incompetent, that he would harm or was likely to harm people at the dealership. And so, again, these facts don't support that, and the judge correctly dismissed those claims as well. Your Honor, again, I think in sum, the evidence is that the plaintiffs here came in and immediately made a judgment about this new general manager. They did make a complaint, and so in terms of the Farragher and Eller standard, I think we can also say that the plaintiffs failed to take advantage of the remedial measures that the employer had available. They were investigated, these complaints. There was a meeting where Beckley apologized for the Make America or Make Priority Great Again comment, and tried to provide what the plaintiffs were looking for in terms of a pay plan. Again, the plaintiffs quit that same day, and we're not going to allow Priority to remedy the things that they were seeking. So for those reasons, they've also failed on the hostile work environment claim, and the district court correctly found that summary judgment was appropriate.
I probably could find this somewhere, but Michael Gadsden, do you know whether he was black or white?
I don't, Your Honor.
Is that it?
I'm told he was black, Mr. Gadsden.
Thank you.
And so, thank you. That's it, Your Honor, and I appreciate your time.
All right. Ms. Brown, you have some rebuttal?
Yes, Your Honor. With respect to the statement about coming over to the white side, it is noted on page 745 of the record that one of the plaintiffs, Mr. Christopher Hall, heard that statement. That's the first thing. The second thing is the call that was made, or the call that was played
But that was
by
traced
both.
down. That's a little unfair, because if you trace it down as to who said it, who he heard it from, and who he, in other words, it went about 3 levels, and the person that it's imputed to denied making that statement.
No, Your Honor, my client testified under oath that he heard the other white employee state, "Come over to the white side." He's not saying that somebody told him it was said. It is noted in the record that he heard the statement himself, and that's on page 745 of the record.
Who spoke it?
Are you asking who actually made the statement?
Yeah, you said your client heard it.
Mm-hmm.
From whom?
So if we take a look at page 745.
That's 745?
That's correct, Your Honor. In the record, the question was, is it also true that you yourself heard the statement regarding getting on the white side? And Mr. Hall stated, yes.
But who was the employee who allegedly said the white side?
So the name of the employee who made that statement was Lolly. I don't have the last name, but that person's name is in the record, I believe. And again, my client stated that he heard that statement being made.
But did he hear it? The question is, like, did he hear it? Did he hear somebody else say? I mean, what I can't figure out from that is, like, is that him saying, I heard this statement from the person who said it was said, or from, right, did he hear, what it doesn't say is, did I hear it directly or did I hear it indirectly? Did I hear it through hearsay or did I hear it from the person who made the affirmative comment? And so he's just saying, yes, I heard it, but what we don't know from that is whether he himself heard it from the person recounting it or the person who said it.
If I may, Your Honor, the question that was posed at his deposition is it also true that you yourself heard the statement regarding getting on the white side? And his response was yes.
I know, but that doesn't help a thing, because the person who told him has to be talked about. You said that was Lally?
Lolly is the person who made the statement, and my client
Okay.
heard what Lolly make
Okay, and
the
was
statement.
Lolly deposed?
Lolly was not deposed in this action.
Okay,
Do we know whether Lolly was reporting that as to what somebody else said, or that was Lolly's own statement?
I believe it was Lolly's own statement. There's no evidence.
challenge that I've got with that, right, is that this statement is referring to something. The problem is the record that we have doesn't include the prior page of the deposition that describes what this statement is, right? And so this statement on page 185, presumably, of the deposition, which is not at page 744, this statement, I have no idea what that's referencing, right? So this statement could be either the direct statement or the indirect statement based on the record that I've got. I've got to interpret what the word "this statement" means. And since I don't have the record, I don't think I can reach the conclusion that you're asking us to.
Sure, and I think ultimately, Your Honor, what I'm trying to get across is that with everything that's happened, with everything that's listed in the complaint, I'm not in the complaint, but in the briefing that we've submitted to Your Honors, through the totality of the circumstances, the question is, can a reasonable jury find that with the come over to the white side statement,
Right, but
that
the point
with
is,
the
this statement, I can't read this and get anything out of it because I don't know what this statement is referencing. I don't get to take this statement out of context and understand it to mean anything, right? Because I don't have the prior page I have no idea what the prior page says, right? Like, I only get the record that you give me, and like the record doesn't tell me what this statement is referencing.
Sure, Your Honor. In Freeman versus Dow Tao Corp. In 2014, the site is 750 F3D 413. This court held that evidence of how others are treated in the same workplace can be relevant to a hostile work environment claim, and the fact that an employee does not witness statements made to third parties does not bar those statements' considerations when we are evaluating a hostile work environment claim. So regardless if that is interpreted as my client heard it himself or he heard it from another person, we submit to the court that based on this court's prior decisions, that all of these occurrences should be considered when evaluating the hostile work environment claim. And so in addition, Beckley refusing to meet with the plaintiffs, throwing their belongings away,
Well, let me ask you
calling them
something.
and other black employees thugs, telling
Could
them...
I get back to that right side? The question is, I understand Hall heard it from Cornelius, right?
Mr. Hall has testified that he heard the statement himself, Your Honor. That is our
Yes,
position.
he said he heard it from Cornelius, that's at 539, and that he was not aware that Cornelius and Richardson had both later stated that Cornelius had said right side, not white. Hall also states in his deposition that a different employee, Alston, also told him he heard the comment. And then they go trace it down to the person who actually said it, and they said it was the right side. Cornelius did not say that himself. He was repeating what somebody else had said.
That is correct, but
Okay,
that
well,
doesn't mean that my client didn't hear the statement himself either.
He heard it from an employee who was reporting what somebody else said, and somebody else said, I didn't say right, I said white, I said right. And the question now is this admissible evidence in a trial?
I do believe it's admissible evidence if my client heard it himself, and the person, the deponent who stated it, was listed as a witness in this case and could be called to testify.
Cornelius was reporting something that was said to him, and that was run down in the depositions. And when they finally got to the person who was really said it, said, I said right side, not white side.
That's a statement that the employers receive from a current employee, Your Honor, and I think a jury can look at that.
This is testimony among the employees. And
There was never
you're trying to suggest that the work environment was hostile because your client heard white side when that was an inaccurate report of what was actually said. Now, that wouldn't be admissible evidence.
I think that is a material dispute in fact. If my client is saying he heard one thing, obviously they can, but they can
justify that, but that's
right.
acceptable.
But an employer can have an employee create a statement that says, "Oh, I didn't actually state that." When my client, again, when the facts should be.
No, this is a hearsay question. In other words, Cornelius was reporting what somebody else had said, and when you run that down to somebody else, the reason for the hearsay is important because that person misheard because the person who actually made the statement corrected it. Anyway, I understand your point. You say that's factual, but to suggest that that misinterpretation and communication of that created a hostile work environment when the person making the statement talked about something totally different.
Well, I think the determination that it was a misinterpretation, again, is an issue of fact.
It's undisputed. Nobody disputes what the original person meant.
But there's a dispute as to what was said. My client heard what was said. He testified under oath that he heard what was said.
I think we've gone pretty far, and we'll cut it off here. But it's a big record. We have to pay attention to all of it, and so we will do that.
Thank you, Your Honors.
At this point, we would come down and greet counsel, and as you know, that our protocols are not following that. But thank you very much for your arguments, and come back again, and we'll shake hands and greet each other appropriately. We'll proceed on the last case today. Alderson versus Lincare, Inc. And Mr. Goroff, whenever you're ready, we'll hear from you.
Okay, thank you, Your Honor. I still have a few minutes to say good morning, Your Honors, and may it please the court. Your Honors, established law holds that courts should be loath to second-guess a company's enforcement of its compliance program, especially one in a highly regulated industry, because those who oversee such programs must have flexibility to impose different punishment for what they regard as different misconduct. Here, the district court committed reversible error in finding plaintiff and her male comparator supervisor were similarly situated for purposes of her gender discrimination claim when, as a matter of law, they were not, and by finding pretext when there was none. And the court compounded that error by imposing punitive damages when a Lincare employee merely followed standard practice in advising a regulator that plaintiff's license had expired based on information on the regulator's own website. If I may begin with the question of similarly situated and look first at plaintiff's conduct. Only plaintiff used cloned progress notes. These are notes in patients' medical records that are the same from one patient to another. In this case, Lincare's chief compliance officer, Jennifer Peterson, learned through an audit of ventilator orders coming from its Parkersburg, West Virginia center that identical handwritten progress notes appeared in electronic medical records of multiple patients made by multiple doctors that indisputably violated Lincare's compliance program. Medicare strongly cautions against using clone notes to support medical necessity for equipment, especially when reimbursement is sought. And that's discussed. I'm going to cite to the appendix, and I'll call it A, so that's at A998. This was so serious that Peterson and Lincare Senior Corporation Counsel and its National Healthcare Service Manager flew to West Virginia to investigate. There they interviewed plaintiff and learned she possessed the exact same clone notes seen in the audit. She kept 17 templates of these in a binder in the trunk of her car. That's at A919. She admitted using them, including personally handing these out to physicians, which they then signed. That's A920. She admitted doing so for 1.5 to 2 years. That's A937. She admitted Lincare believed
Can you say that, and they signed? Were they able to be signed without filling in the necessary information? I I mean, they were like go-bys, right? They were templates. They weren't signed as she provided them, right?
The text was signed, but you're correct. And actually, that's one of the points I want to call to the court's attention when I compare the good chart note examples with the clone notes. The clone notes are you take the text and you plug it in by just filling in at the top. And you can find an example of this at A653, the patient's name, social security number, date of birth, address, phone number, physician name, and physician practice. But otherwise, it's the same. So if you looked at, Smith's...
Are they I just want to make sure I'm understanding the facts. These are handwritten notes. So they're like taking the what you call clone notes, and then they're handwriting them out. They're basically copying it like a go-by, filling in the gaps.
Well, actually, no. The medical information is pre-written. And in this case, it's pre-written by the medical practices themselves. Ms. Balderson, plaintiff, her violation was that she used and kept these. She had them at the ready in the trunk of her car, and she would give them to physicians, and then they would sign them, and then she would use this to process their order for ventilators. And she had no authority, ability, right under the compliance program to be doing that. And only she used clone notes. Mr. Brady, her comparator, did not.
Do we have in the record an example of a clone note and then the submitted signed document?
I do, yes. In fact, I'm hoping to focus a lot on the difference between Defendant's Exhibit 12, which begins at A651 and goes through A650.
A651, okay.
Yes, I'm omitting the zeros, A00651 to 655. And I'm contrasting that when I'm done, with Your Honor's permission, with A00656, which is the examples of the good chart notes Mr. Brady used. So if we, since Your Honor's question is on the note itself,
If notes were a diagnosis, basically, wasn't it? A canned diagnosis?
yes, and in other words, instead of,
There was no fill in the blanks in the notes. The note was totally prepared, and all the physician had to do is to sign it.
exactly, sign it, fill in the name of the particular
And
patient.
since he wanted reimbursement or facilitated reimbursement, he signed whatever she presented.
Correct. She came with these
And
notes.
that violated the standards of the company as well as Medicare.
Well, it violated the standards of the company. One of the issues of the Lincare made no determination that it actually violated the law in any kind, but it absolutely, indisputably violated the most sacred of the compliance program standards. So only she did that. And if I may stay with Defendant's Exhibit 12, she did more than just present these to be signed.
All right, so can you show me at 651, what is the piece that the plaintiff provided?
Okay, so the plaintiff, her name is Chandra, so it says from Chandra, sent a 4-page fax. And the cover of the fax, excuse me, Your Honors, begins with 3 violative statements that she wrote. These are hers. I need face-to-face notes with the last 6 months that met.
So I get this point.
Okay.
This is a separate issue than the 19 go-bys that she had. What I think of as go-bys, because I'm a lawyer, right? That's what the phrase we use. But I understand this, but that's separate from the 19 that she had in the trunk of her car. That's what I'm trying to see.
Right, so
Can you show me one of the 19 and where it was applied?
Sure, the ones that were submitted are in Defendant's Exhibit 9, and let me see if I can get to that quickly. That's at A609. They begin, and then there's 19 of these, and if you look, you see, a series from this Camden Clark Medical Center, and they're identical. The patients are different, the dates are different, many of the, but the text, as Judge Niemeyer said, is absolutely identical.
So counsel, to be clear, the handwriting on 609 through 615 forward, that's Miss Balderson's handwriting?
No, Ms. Balderson did not create these notes. The handwriting on 609 forward, the testimony was from people at the medical practices. She said that she kept these, which was a violation of the policy, and she used them. She would come and she would hand them to physicians, she said, to help them out. And they would sign, and she would take, and she would shepherd their order through. So her violation was not to draft these, it was to keep and use them. But Medicare, physicians get to make the choice. But Medicare cautions them in its guidance, and we cite this at footnote 7, page 11 of our brief, cautions them not to do so, or to be very wary in doing so when you're doing claims of reimbursement. And so only she used clone
The
notes.
important point for your case, though, is that it violated, to do that, whether it's a good rule or not a good rule. I think it's probably a good rule because it tends to make individualized treatment requirements universal when they really aren't. It tends to deceive the system. But the problem for you, I mean, the fact for you is that it violates your ethical standards, printed ethical standards. Is that right?
That's absolutely correct, Your Honor.
And that's why she was disciplined.
Absolutely, Your Honor. And she does not question that. She questions that she was terminated when her supervisor was not. And if we can...
Just so I understand, it violates your policy because it's leading. It's like a leading question, right? It's saying, hey, here's basically the information that you need to give me so that I can get you reimbursement.
That's the principal reason, although there could be different forms and degrees of leading. But it's also, it also, in her case, did other things. It was doing a favor for someone who's a referral source, which is another violation.
But that wasn't the reason that your client gave when they fired her. They fired her for leading.
The testimony was that she was told that she was fired for leading through the use of her progress notes. That's what Ms. Balderson testified. She admitted that the leading asked to her was with regard to progress notes.
Okay. And the leading part of that is that she's leading them by saying, here's the information you need to give me in order to get reimbursement.
Exactly.
Right. Okay.
And
it wasn't individualized. It was cloned.
Exactly.
And the doctors don't give it individualized attention because they want the devices and whatever it takes, they signed.
Well, we can certainly say that they signed it and didn't give it individualized attention. I won't speculate as to the motives of the doctors.
But the policy is designed not,
yes,
is in time, tried to create an individualized need as opposed to a cloned need.
So if we may turn to Mr. Brady, the alleged comparator, Defendant's Exhibit 13 is what he did. It's A656. And he gave 3 examples, good chart note examples. And if you were to look at that, Your Honor, and compare it with the clone notes, you'll see first, these are typed. You'll see second, these are all on one page. You'll see third, these are said to be examples. And Mr. Brady testified he never used clone notes. Ms. Balderson agreed he never used clone notes. He testified, Medicare allows for educational material such as this.
Why is it not just as leading, right? So one example, I mean, to me, I guess I'm having a hard time understanding why, based on the policy, right? I understand that they are different, but they are both equally leading, right? In one instance, you've got somebody saying, here's something you wrote, you physician's office wrote, that meets the criteria, and so I'm showing that to you, and that's leading. Here's the other hand, the guy saying, here's something I wrote, but if you copy this back to me, it meets the requirements, right? So in both instances, from a leading perspective, it might have other problems, but I want to stay focused on the question of, is the one more leading than the other? They strike me as equally leading.
The critical difference is that clone notes are used with actual patients. If you look at all of the clone...
But so are the good chart notes.
No, they are not.
The whole point is...
They are not, Your Honor. I'm sorry to interrupt you.
No, because the testimony is that the trial testimony was that the language from the notes ended up in a number, we don't know how many, patient charts. So they copied this language into the patient charts the same way this language was put into the patient's chart.
Well, first of all,
609.
First of all, that would be what Mr. Brady said, is he never directed a physician to do so. He didn't ask physicians to do so. He had no role in
Wait, I'm sorry. So if I tell you, hey, this is what's good,
Right.
I've got no idea that you're going to use it. I mean, that's like hard to get my head around, right? I mean, if we say, here's the order, this is what, we expect you to provide, like, we're implicitly saying, like, provide us this.
No, we're not, Your Honor. If I say put this into David Goroff's progress note, into his patient chart that is submitted to Medicare for reimbursement, that is very different from saying examples. I'm training you on the kind of language that you would use to try to convince an insurance company to provide coverage for your patient. All of these have to be modified. They speak, for example, of CPAP/BiPAP if you look at 656. Those are two separate devices. You couldn't just verbatim copy these, and that's what Mr. Brady said. These were not plug and play. They couldn't just be put into a patient record. A physician would have to think about it, modify it, and make the ultimate election. If you look back at DX12, Defendant's Exhibit 12, Ms. Balderson is saying, I need you to do this. I need you to sign this. I went ahead and I changed the document. I went ahead and filled this in. That is actively being involved in a patient record, and it resulted in an error. It resulted in something that said a patient had conditions they didn't have. Mr. Brady did no such thing, and more importantly, this is a gender discrimination case. The question is, did Lincare have a reasonable basis to believe this was different, such that what he did was of lesser magnitude? And it absolutely, if you look at these two and you look at her direct involvement, that shows that there's absolute justification. And Ms. Peterson testified she always punished use of clone notes with termination. And she did so with men over the years. And there was no evidence to the contrary of that. And, in addition, I obviously want to preserve on punitive damages. The court, we shouldn't get there because of liability, but the court also looked at a different decision maker. It was Sandra Moreau versus Jennifer Peterson, who acted post-termination based on information that was provided by the regulator, which was incorrect. And all of the district court's findings of indifference and hostility and actual malice were based on the fact that there was an assumption that Lincare knew that the regulator had made a mistake in its website when the notification the regulator provided did not go to any of the decision makers. They did not know about it until the case began, so it amounted to strict liability. And I also see my time is up. I'll respond in rebuttal to the after acquired evidence argument I expect opposing counsel to make. Thank you very much, Your Honor.
Thank you, Mr. Robbery.
If it may please the court, Andrew Roby, I represent Ms. Chandra Balderson, the plaintiff below. At the outset, I want to frame the issues. Lincare is not suggesting here that Chief Judge Johnston was acting under some misapprehension of law. Rather, Lincare is simply disagreeing with his factual findings and the weight afforded to particular evidence below. By attacking these factual underpinnings, Lincare is necessarily trying to retry this case on appeal based on the pages of a cold record. We need to be mindful of the standard of review here, which is a narrow one. If the district court's findings were plausible in light of the record as a whole, and they need only be plausible, then this court must affirm, even if it, sitting as the trier of fact, would have decided differently.
Well, let me ask you this. This is the part that gave me the greatest difficulty. The only evidence of discrimination that the district court gave, it was a single sentence. It says, is that she was a woman and the other person was a man, and they were treated differently, and therefore discrimination comes. Not only that, the testimony was by your client that there was no mention of gender discrimination in any of the discipline. She was always treated fairly as a woman. She was disciplined by a woman who had 2 women advisors, and she was replaced by a woman. And so the question is this sexual discrimination? Where's the evidence of it except for the fact we have a man and a woman involved?
So, Your Honor, I'll start first with the standard. Under the McDonnell-Douglas standard, direct evidence...
Just stick with my question. We can go, I understand the McDonnell-Douglas standard and the presumptions and the shifting presumptions and all that stuff. But the idea is at the end, you still have to find discrimination, deliberate discrimination based on the basis of sex. And my question is just where does, in the record, other than the fact that one was a man and one was a woman, do we have evidence that there was discriminatory animus or any kind of discriminatory evidence? And I couldn't find any other than the fact, and the district court didn't list any, except the one sentence near the end of the opinion that he relied on the fact that there was a difference, the main difference was two were treated as one was a man, one was a woman. That was the whole case.
So direct evidence is not required in a case like this.
I understand, but I still want to know what evidence you have. If you say you don't have any, fine. You're relying on that.
The evidence is disparate treatment in applying the company policy.
Based on the fact that one's a woman and one's a man.
That's correct.
Okay.
So then we move to the
question is, that doesn't seem to appear to be the basis. In other words, what we have is a total women cast participating. You have the plaintiff, your plaintiff, contending that gender and sex in the workplace was never an issue until they dismissed me. And then when she was finally replaced, she was replaced with a woman. All right, you can go ahead and argue. That's my trouble.
So the last part of your question, you mentioned that Ms. Balderson was replaced by a woman. It's important to note that the person accused of discrimination is not the one that hired Ms. Balderson's replacement. Your question also addresses what is being called the same group inference, this idea that females can never discriminate against other females.
No, I don't suggest that. I suggest that there was no complaint she was treated hostilely because she was a woman. The fact is she was comfortable being a woman in that workplace, and not only that, she was disciplined by a woman, and the three came down to interview her. They were all women. The point is, this might be an unjust decision. This may be a decision where they treated people differently because he was higher up or had more responsibility or whatever, and they were showing favoritism. But the question is whether there was animus, discriminatory animus based on sex is really, it's about as blank as you can get.
So hostility is not required. This is a single claim under West Virginia law, under the Human Rights Act. And West Virginia law recognizes a claim for disparate treatment. And our claim is that you have, over at Lincare, a uniform policy, and it was applied disparately across a protected class and a non-protected class. Under West Virginia law, that is more than sufficient to state a claim for disparate treatment. But ultimately, this comes down to weighing evidence. The fact that Ms. Balderson was terminated by a female...
That's what I asked you for, is evidence, and the only evidence we have is that Balderson was a woman and Brady was a man. That's the evidence.
It's the disparate treatment in the policy, and I think the disparate treatment is further highlighted by the facts that also gave foundation to the punitive damages. The punitive damages were...
Can you talk to me for a second about the findings of pretext? So the district court seems to rely on two ideas. One is this notion that there was a shift in the explanation. And then second, there's a failure to report. On the shift in explanation, help me understand why that's actually a shift, right? Because, you know, your colleague, when we started talking about leading, immediately turned to the very things, this alleged misrepresentation and false documentation that the district court found wasn't about leading, that it was something else as opposed to a subclass of leading. Help me understand why I should not think about the misrepresentations that are alleged here as really a subclass of the leading that was being done. It was happening because of the manner in which she was leading the physicians.
So, I mean, your question raises an important point. And below at the trial, the distinction was not some distinction between templates or good chart note examples. At the time she was terminated, all the conduct was commonly characterized as leading. When Ms. Balderson was terminated, she was told she was being terminated for leading. We served discovery request. And
I understand, but why isn't the later discussion about the misrepresentation and false documents part of that broader category of leading, right? That resulted from the leading. That was a consequence of leading, not a shifting explanation. I don't see that as the shifting explanation. That's what I'm trying to get at. I understand you want to talk about something different, but stay focused on that piece for me.
the district court found that there was no misrepresentation. So regardless of whether the explanation was changing, the district court looked at the facts. There's a facts that Lincare
Right, they
refers to.
found there's no, but what was there was leading, right? So maybe it resulted in misrepresentation, maybe it didn't. The point is, the whole idea there was leading, right? And so none of that seems to be a shift, right? The district court wanted to say, oh, that's totally different, but that's all part of leading. I agree with you. Leading is this sort of broader category, but it encompassed the subsequent allegations. And we've said in other cases that in instances where a second justification is fully consistent with the first justification, we can't use that to imply pretext. And that seems like exactly what the district court did here in violation of our prior precedent.
So this is why we do not reweigh these factors on appeal. Chief Judge Johnston inquired at trial himself, trying to draw out what is it Lincare is claiming are the distinctions here. And at trial, the true distinction Lincare was trying to raise was they were accusing her of federal crimes. And through a series of admissions, the district court found that this excuse was simply made for litigation and was not to be believed. So
But it's wholly consistent. Here's the problem. Assume for a minute it was true or false. It matters not whether what happened was misrepresentation and false. The point of it and the violation that occurs there is because she's leading. That's what leads to it, right? So it's a subclass of leading. And we've said where a rationale that's given is wholly consistent with the first rationale, we can't from that conclude there's pretext.
if both Mr. Brady and Ms. Balderson were leading, that's the same violation of corporate policy, and the same punishment should have been doled out.
Totally get you there, totally get. But what it doesn't do is get you pretext. All right, so I think we're good. That doesn't establish pretext. So now the second piece, he only relies on two things. The second thing he says is pretextual, is they didn't report this to HHS, right? Help me understand why that shows that the reason they gave was false.
It highlighted why Lincare was not credible. One of the subset categories of what they claimed was the distinguishing factor was these misrepresentations, intentional misrepresentations. Under the corporate integrity agreement, Lincare was supposed to report any known or even suspected violations of federal health care law. Now, during discovery, Lincare's corporate representative said she definitely violated the False Claims Act, and she probably violated the anti-kickback statute. They're accusing her of federal crimes. So the question to Lincare was, and this was in the deposition, and this is at trial, you're accusing her of federal crimes. Did you report this?
The kickback statute? Why, how did she violate the kickback statute based on allegations?
Well, they claimed somehow using these templates was a violation of the anti-kickback statute. In the deposition testimony, they ran away from that at trial. But this is all to say, Chief Judge Johnston, the finder of fact, just could not believe any excuse they were providing. And that's a credibility determination.
But he gave two very reasons, right? So one, if he just said, listen, I heard the witness talk and that guy came across like a liar, all right, that's a strong credibility point. But what he's raising two specific arguments,
Sure.
right? And so we defer to his factual findings, but we don't sort of blindly look at the conclusions he's drawing that a failure to self-report means that you're acting pretextually. Like, that's the part that I'm not, like, the fact that I don't turn myself in, like, doesn't tell me a whole lot about whether I did it or didn't do it.
So the fact that they did not report what they say were suspected violations gives rise to two possibilities. The first is that there are material breaches of this corporate integrity agreement, which has the risk of excluding them from federal healthcare programs. The second possibility, and the one Judge Johnston found most likely, was that the excuse was totally disingenuous. So by...
I'm sorry, the excuse being leading? That it had nothing to do with leading?
Correct. So leading...
That's the conclusion you draw from that.
They said leading...
You think that's a reasonable... I just want to make sure I'm understanding. That's what you think the reasonable conclusion is?
I'm sorry, maybe we're talking past each other. If we could rewind.
No, I'm fine. If that's... I just want to understand what your position is, right? What I'm trying to understand is, what does the failure to report tell us? How can I get from that pretext?
So leading was identified as a probable violation of federal healthcare laws. So Lincare could either report that if they thought that was seriously what was going on here, or they could not report it, and for not reporting it, that's why Chief Judge Johnson found that their excuse was disingenuous. If they truly believed that leading was somehow a violation of federal healthcare law...
So take me back to the finding, to the initial discharge. I thought when we talked about the discharge, she was discharged for violating the corporate policy, not for violating federal law. The corporate policy presumably is broader than the federal law.
It's broader, but there's significant overlap, and at the time of heading into trial, Lincare was accusing her of both. The complaint did not originally...
What are the two things there? The corporate policy and federal law?
Correct.
When you say federal law, is that written federal law or regulation?
It's in statute. They accused her of violating both the anti-kickback statute and the False Claims Act.
Well, why is it a false claim?
We haven't gotten deep into whether that is an actual violation.
To whether the corporation had could recognize a need to report, because if they really had to report, I'm sure they would have. They concluded in their self-interest not to report because it could disqualify them, and this was an internal corporate matter that they were addressing and getting rid of the problem.
So before Lincare was confronted with the existence of this corporate integrity agreement, they didn't realize we knew about it. That's when they were accusing her of violating these federal healthcare laws. It was only after they were confronted with this document they said, well, we don't know if it's a violation or not, so it's not reportable. But importantly, under that agreement, they're supposed to report something that could possibly be. It doesn't have to be a known violation, but a probable violation.
Can I back up and make sure I understand that? Your position is that Lincare was unaware of this agreement until you brought it to their attention.
I'm not suggesting Lincare as a company didn't know about it, but when...
It sounds like they didn't, in which case, like, we get even less out of their failure to do it, right? The people involved in this litigation, it sounds like what you're saying, didn't know about this. And so the fact that they failed to comply with something they didn't know about shouldn't tell us much about their state of mind.
So the person, their corporate representative, was the chief compliance officer for the whole company. She certainly knew about this corporate integrity agreement. Indeed, I think she signed it, or at least notice was required to go to her under the agreement. So she knew about it. When she was providing testimony, trying to draw a distinction between Mr. Brady's conduct, Ms. Watterson's conduct, she was freewheeling. She was like, you know what, this is different conduct because she was violating federal healthcare law. Only when confronted with that agreement did she change her tune. And she was confronted with that testimony. Chief Judge Johnston noted that issue and appropriately discounted her testimony as false. And that's, again, a credibility issue that should be afforded great deference on appeal. I see that my time is up. I will address my cross appeal on rebuttal.
All right, Mr. I guess Goroff, we have, yeah.
Yes, thank you, Your Honor.
We have 5 minutes, and I guess Mr. Roby gets another 5.
Because of the cross appeal,
right,
although,
okay.
yes. So if I may respond to one of the things that Mr. Roby said that I believe is inaccurate. Lincare was never accusing Ms. Plaintiff of violating the actual statutes. The violations were of the compliance program. What he is referring to is there was a 30B6 deposition, and the notice of that is at page 28 of the appendix. And it did not, and Peterson was the representative. It did not include among the questions whether there were actual violations of law. Lincare has in its policy, as Judge Richardson, you pointed out, a broader scope of prohibitions designed to ensure that no law is violated than the law itself. So things can violate Lincare's compliance program without violating the law. And Ms. Peterson is, for 20 years, and more than that now, familiar expert as one can be in compliance, but she is not a lawyer, and there was never a determination made. So they had these set of topics, and they asked a series of questions in kind of staccato way, where we were talking about leading before, where the lawyer says, did this violate the compliance program? Yes, it did. It was leading. Did that violate the compliance program? Yes, it violated this. Did this violate the compliance program? Yes. Did this violate the False Claims Act? And suddenly it went from the compliance program, the noted topic, to the violation of the law itself, and she continued in the yes it did, yes it did, yes it did. When she looked at the transcript, she said, that's an inaccurate answer I gave, because I'm not equipped to talk about the law. I wasn't noticed to talk about the law. And so what she did was she submitted errata, and then she also said, and this is very, very important, I am available at your wish to be deposed a second time about why I have changed my answers. And plaintiff's counsel elected not to do that. And had they thought it was true evidence of pretext, they could have grilled her all day about that. They chose not to. They forfeited that opportunity. And as to the corporate...
To your knowledge, is that the only part of the record in which your client or your client's representative testified that this was a violation of the False Claims Act or the anti-kickback statute?
That is my understanding, yes. And so as to the agreement, they didn't report it because they hadn't made a determination of scienter. They don't have to. Ms. Peterson testified that when Judge Johnston asked her that she would terminate someone irrespective of good faith. Their state of mind does not matter. They look at behavior. And importantly, Judge Johnston, in the opinion, said that there's no showing the plaintiff set out to commit healthcare fraud. Well, that seems to show that one can look at clone notes and all the various violations that the client found to be leading and come to a reasonable conclusion that that wasn't a violation of law because the judge did so here. And if the judge could do so here, then Lincare, without getting into their privileged communications and all that, can make its own judgment too without that being pretextual. Most importantly, there is nothing in any of this that goes to gender being the real reason or a fair inference from what was done. Since I guess I'm going first on their cross appeal because Mr. Roby said he'll address it next, but this involves after acquired evidence. There's no question that post-termination, for the first time, Lincare learned that plaintiff had stated that when she applied in 2015, in October of 2015, that there was no restriction on her license for Ohio, which she listed on her application. She checked that there was no restriction when in fact there was. And the application itself says that's cause for termination. And plaintiff admitted at page 60 of her opening brief that that was cause for termination. And Lincare's corporate representative stated that that warranted termination. That's page A1021 of the appendix. And Lincare said it absolutely, violates Lincare policy. And she had a duty one of her duties she was being hired for was to provide clean paperwork, to ensure that there is clean paperwork, meaning that it complied. And obviously, if you are lying or misrepresenting in your application, that goes to the kind of credibility to provide clean paperwork. Judge Johnson certainly had the power and authority to look at this constellation of evidence at trial and draw the conclusion he did, which is that Lincare prevailed in its after acquired evidence defense. We, Your Honors, don't believe you need to get there because we believe the underlying decision should be reversed. But if not, that piece of the damage limitation we believe should stand. Thank you.
All right, Mr. Roby?
Thank you. In order to sustain an after-acquired evidence defense, two things, among other things, two things are required. There needs to be evidence that Lincare could indeed have terminated Ms. Balderson, and evidence that they would have acted on that. I call it could have and would have evidence. Now, Lincare has certainly presented some evidence that could lead us to believe they had the right to terminate her, but they have not provided any evidence on the latter factor that they would have indeed acted on that. When asked directly at trial, Lincare corporate representative, would you have terminated Ms. Balderson for this omission? The answer was, well, I don't know, maybe. We'd have to discuss it internally. So we believe the court below acted under a misapprehension of law by accepting only could have evidence as sufficient to sustain their after-acquired evidence defense. In our papers, we asked for Lincare to identify where, anywhere in the record, is there evidence that Lincare would have terminated her for the omission on her application, and they have failed to identify any such evidence. So, in conclusion, the record is devoid of critical evidence necessary to sustain that defense, and as such, this court should remand the case for the very narrow purpose of fashioning a lost wage damage award in light of the existing trial record, and it should affirm the lower court's decision in all other respects.
All right, thank you. All right, as I've mentioned, you guys may have heard that back in the 1930s, Judge Parker established this wonderful practice of coming down and shaking hands and sealing the relationship between the bench and the bar. And we've followed that ever since. And of course, our protocols now bar us from doing that. But we do come down virtually, so to speak, and shake your hands. And thank you for your arguments. Next time you come, I hope we'll be in a position to carry on with our tradition. We'll stand adjourned for the day.
This honorable court stands adjourned. God save the United States and this honorable court.